Order, order. We're now in session. Very warm welcome to you, gentlemen. And Dr. Hussain, welcome back for the second time. Just for the benefit of the public record, we were trying to question Dr. Hussain a few weeks ago, and we were interrupted by so many votes, he didn't get much of a chance to give evidence. Now, just for the record as well, perhaps if you would all state who you are. So, Mr. Davis.
My name's Trevor Davis. I'm the CTO of an ISP called Timiko.
Much.
My name is Gas Hussain, and I'm the Executive Director of Privacy International.
Mr. Walker.
Dave Walker, Managing Director, Label Security Limited, but just here representing myself.
Very much.
Casper Bowden, I'm an independent privacy advocate. Formerly I was Director of FIPR and more recently Chief Privacy Advisor to Microsoft, but I represent nobody other than myself at this meeting.
Well, thank you very much. We're very grateful to you for coming, and we're looking forward to the evidence you've got to give us. Mr. Hubbard.
Thank you very much, Lord Chairman. It's very good to see the four of you here. One of the issues that I think a number of you have raised concerns about is how broad Clause 1 of the draft bill is, that it captures a huge range of information. This is related to Home Office's claimed data gap. Last week we were told in public session by the Home Office that their intention was to use the bill to plug two specific areas of the data gap: information relating to IP addresses and information relating to weblogs. If the legislation could be drafted narrowly to only allow notices to capture those areas from CSPs domestically, would that significantly allay your fears about the scope of the draft bill?
Yep. I take it from when you say weblogs, you mean details of websites visited?
Only up to the first slash, as is currently allowed under RIPA, without the sort of identifying features later, but which is not kept currently if it's not for business purposes.
I guess there are two sides to this discussion. One is the straight technical side from an ISP's perspective. Many ISPs will already store information of the IP addresses. We, as a business ISP, we only provide people with fixed IP addresses, and these won't change from one year to next, to be honest. The bigger consumer guys and the mobile ones may well change them quite often, and so physically it's probably not too difficult a thing to do. From the weblog information, most small ISPs would probably have to put some investment in technology in order to be able to support it. But again, it's not too difficult a thing to get your brain around. I guess from the point of view of the other side, which is the privacy side, it's whether narrowing down the information to just those two areas significantly reduces the amount of information that you can drill into about a person. I guess some of the responses that we saw in the written response, one from, I think, was it from the Tor project, said that 23.3% of Wikipedia users could be uniquely identified from the used data. Okay? And you only have to look at the recent news that came out about House of Parliament, where there are only 2 IP addresses that are used to access the internet from here, and the fact that it was possible to see that a number of the Wikipedia changes to members' profiles had been modified from within the House of Parliament. So, you know, you can ask yourself, you can sort of say that a lot of information could be gleaned about somebody still if you were drilling into phishing IP address information.
Yes. Please, members of the panel, please feel free, all of you. If you have something to say, say it. That's not just one each. But if you have nothing else to add, then we'll move on. But yes, Dr. Hussain.
Following this revelation last week, we did a consultation with our friends and colleagues in industry, both domestic and abroad. And when we spoke with the telecommunications companies domestically, they informed us that they already do record the information the Home Office is seeking under the Digital Economy Act. So it wouldn't actually require any of this discussion. This bill is not necessary for achieving that objective. Now, when we're talking about weblogs of, say, the providers, the foreign service providers, for instance, when we spoke with some of the major players, whose names I cannot mention, they expressed their concern about the idea of being compelled to collect this information because although they process it, they do not collect it and they do not store it. And this entire scenario seems to be generated because we're still using IP version 4, and they believe that this would all be solved within a couple of years when everybody moves to IP version 6. So it does seem odd that we have this massive piece of legislation with a vague objective to solve such a small problem that, in a sense, is solvable already domestically.
Can I just bring you back, I'll come to other panelists in a second about this Digital Economy Act issue, a controversial piece of legislation, as you know. Are you saying that all of the domestic providers specifically have everything that the Home Office said last week? And would any of these providers even anonymously be able to write to this committee to confirm that? Because I think it would be very helpful if, in fact, they already have it all.
Yes, and I asked one of the providers for them to say so publicly, and they responded saying they already have in a submission to Ofcom. And so in our written evidence, the first footnote refers to exactly that public source where they state as much.
Thank you.
Yes, Mr. Brown. Yes.
I don't know what was said to the committee in secret session by the Home Office, so I'm trying to sort of read between the lines about what information you've received about weblogs and IP addresses. But certainly one aspect of this that I've been concerned with at European level is I sit as an independent expert on the European Committee to implement the Data Retention Directive for the past 3 years, and this subject has cropped up, as you might expect, in that committee. So if I could just sort of rehearse and clarify what the issue is here. We're talking by weblogs about logs of websites visited retained by the internet service provider, and the internet service provider would only be able to do this by essentially intercepting the stream of packets en route to that third-party website, because, as it were, that traffic between the user's computer and some other website is, in a sense, nothing to do with the internet provider. The internet provider's function is merely to convey packets from A to B.
But it knows, presumably, where B is in order to convey the packet to B.
Not really, because at that level, the packets are just datagrams which are just passing through the internet service provider's pipes. Sometimes, or not so much now, internet providers used to operate something called a transparent cache or transparent proxy, where they would keep copies of frequently requested web pages from all over the internet as a local copy. But that's really not done very much now at all. So I think the committee should be clear that this proposal for ISPs to log websites visited is intrusive, and frankly, it lacks a legal basis. There is no basis for doing this currently, as I understand it, under UK laws or secondary legislation that have currently been enacted, nor is there any legal basis for doing this under European data retention. Now, there are technicalities in European data retention and the intersection between European and domestic law which might permit this, but it's, I would say, dubious. And indeed, if this is going on today, if internet service providers are retaining website information about websites visited, this is something that was discussed by the European Committee, and European data protection authorities took the view that this was illegal. And this is something that should not...
I'm a little concerned we're getting different messages, but Mr. Davies says that this is easy to do. Dr. Hussain said...
I can understand how you would
that it's
do it.
That it's doable. Dr. Hussain says that it's already legally required. And Mr. Bowden says that it can't be done.
I think we're talking about different aspects of it, where what I was speaking of was whether or not a local mobile phone provider, domestic mobile phone provider, would record the IP address given to a user and the source port that was granted to that user for that moment in time. So that may be recorded by the domestic mobile phone company.
But,
That's right. So
but
it's
not the URLs that they go to up to the first slash.
Casper's addressing the URL issue.
Thank you.
So two different issues, the website logging issue and then the IP and source port number issue. Totally different issues.
Fine.
Yes, Mr. Walker. Yep.
I agree with Dr. Hussain that it's a curious matter of timing in that the nature of proxying that has been required with IP version 4, which can be used, and it's an unfortunate side effect from the point of view of the committee here, that it often conceals the location or nature of a user. That issue is going to effectively go away in the next couple of years with the adoption of IP version 6, which will happen for sound commercial reasons. In terms of the capturing of URL data up to the first slash, it's a very interesting question regarding where that capture is actually feasible from the point of view of whether or not that data is concealed cryptographically at the point at which interception is intended or possible to occur, rather than what was said about Wikipedia, for instance. Wikipedia, even though it's clear text access, is able to identify all the URLs because it would be able to terminate any cryptographic connections to it. Whereas if all this information is to be gathered purely by the ISPs, they may be looking just at ciphertext, at which point the data will not be recoverable.
Mr. Hubbard?
Sorry, I'd like to add that we wouldn't be able to detect encrypted URL data.
I think we were under the understanding there's three categories: open messages, where you can get everything, the URL and the content; ones where the content may be encrypted but you can get the URL; and ones where the URL and content is fully encrypted and you can't catch any of it. That's, I think, my understanding. Yes. Mr. Hubbard.
I think
Dr. Hubbard.
encryption is something which we recognise is a problem. And what you said is very helpful. I'm still trying to perhaps pin you down to sort of yes/no answers if they're appropriate. If Clause 1 were restricted just to either or both of those specific issues, would that, in your view, A, make the bill better, and B, make it acceptable?
You don't need a bill, in my view.
To do that?
You don't need this bill in order to do any of that.
But I mean, a changed bill. I mean, we're not talking about...
You don't need section... The point I was trying to make was that this data is already collected here in this country, and you could try to pass a piece of legislation requiring foreign providers to record this information, but they're more likely to laugh than to adhere to it.
So the IP data can be done without the legislation, and the web logging, you say, is very hard to do.
Well, I mean, I think it's legally hard, and in terms of human rights, it's hard, because if I understand your point correctly, it is, shall we take the premise of Clause 1 that there shall be blanket retention for everybody in the country of certain categories of data? That is still extremely problematic in human rights terms. So I would want to sort of refocus the question on whether the fundamental methodology is collecting data about people there is reason to collect, whether there is some basis of suspicion, whether they're in vulnerable groups, to take a rough figure, whether we're talking about 1% of the population, as opposed to reporting data about 100% of the population. That seems to me the essential principle at stake.
I'm not sure that it really does reduce the scope that much, because looking at the original proposal, which is fairly unclear, because a lot of it is left deliberately unclear. In my mind, a lot of what might be asked of the ISPs to do is very difficult. And it comes down to the encryption and the data being held overseas. So if you take away that aspect of it, which is very difficult, you're down to, I think, relatively straightforward things, but it becomes a privacy, and you come down to non-technical debates then, because I believe that all of this database will eventually find its way to the public domain and people will be having a play with it.
And one of the issues the Home Office has raised is the idea of future-proofing, that the information they need will change in the next few years and the few years after that, and there's no doubt technology is changing. Do you accept their argument about the need to future-proof the legislation, and what advice would you give us on how to practically pass legislation, if it is required, in this sort of ever-changing world?
I think that if you're buying into the concept of storing all the information and trying to catch criminals, then it would be a natural thing to provide future-proofing to it. My only sort of technical observation is that people developing applications and services these days are far more conscious of the need to build privacy into their applications and services. And you can think of Apple iMessage, and I mean, even Skype, for example, is designed to be a private means of communication. Then I think that the future-proofing it as a sort of blanket open book isn't necessarily going to come up with have much benefit, because the technical issues are going to be there.
If I could put my academic hat on for a second, there's no such thing as future-proofing. And an attempt to make something technology neutral as a political act. It's an attempt to say that our understanding now is all we will ever understand, regardless of how the environment changes over a period of time. So in the first question, you heard the answer about IP version 4 versus IP version 6. Well, that's going to change in 2 years. So why are we talking about a program over a 10-year period? And if we look at, say, the debate we had 12 years ago about RIPA, when we were talking about the forms of communications data and how sensitive it is, I would say arguably communications data is much more sensitive now than it was back then. We've never had the review debate about RIPA. We're only having it now, unfortunately, 12 years later. So if we create a legislative framework that is future-proof, it basically means that we will never again debate these matters of principle, and that's very dangerous.
Yes, Mr. Walker, and then Lloyd Jones, and wanted to come in on this point. Yes, Mr. Walker.
Yes, very much again what Dr. Hussain said. If the past and the present are any predictors of the future, it's that the world changes incredibly rapidly, and where we're going to be in 10 years' time, my professional opinion is I have no clue. Therefore, future-proofing a bill in this way seems to be a fairly futile thing to go at, and the only thing that I would suggest could be done to actually ensure that the text of a bill stays relatively current with what the world is doing is that when a bill relating significantly to technology is passed, that rounds of post-legislative scrutiny are put in place and commitments made to do that as part of its passing.
Lloyd Jones on this point.
I wanted to say, Lord Chairman, thank you to Mr. Trevor Davis, his forthright paper, which you submitted August this year, and you say you've got a lot of sympathy for those in the area of law enforcement, and you went on to say, though, we've serious concern that we're going down a path that might better sit in the George Orwell novel. Have you further to add to that?
Well, I mean, we need to get into the vernacular then, don't we, in terms of Big Brother is watching you. You know, I'm not sure that it's a society that we particularly want to live in. And again, it is a difficult one because I want people to catch crooks. I don't want people to fly planes into sides of buildings. And I think this whole debate, this whole bill, really, of all the bills that we've had in recent years, needs a serious amount of debate, because I think the judgment and what we come up with at the end has to be based on very informed debate, rather than something that we just quickly rush through because it's perceived that it will provide a benefit, because I think there clearly are downsides. And I mean, I'll give you an example, a recent example. Since I wrote, it's the first consultation I've ever replied to, I'm on the board of the ISP Association, and I've always left them to do it because they're competent professionals to do that. I'm not a regulatory person, I'm a CTO. But this is the first one I've applied to because I felt strongly enough about the issues. And in the course of thinking about it and writing about it, for example, our taxi drivers. I've had a couple of taxi rides recently where I said, have you ever had anybody leave a laptop in the back of your cab? And I had two taxi drivers who said no, but one of them said in 7 years he'd had 4 laptops left, and one of them said he'd had 8 laptops left in 5 years. And then when you read the written submissions about the MOD losing laptops and GCHQ having laptops stolen, I think it doesn't matter what security and oversight aspects you write into a bill like this, then the information is going to get out in the public domain at some point, and I think there will be big downsides in terms of people having their privacy invaded, and you can come up with all sorts of scenarios. Somebody might be surfing Alcoholics Anonymous websites, or he might have a serious disease that he wants to keep quiet about, or all sorts of personal things, but that kind of information will escape. That's really my biggest concern about it.
I asked my question. We do read our papers, and we are concerned.
But
Mentioned Orwell. Why not read Road to Wigan Pier as well?
okay, I did. I've got it at home somewhere a long time ago.
Well, it's because we've all read your papers that you're all here, gentlemen, giving evidence in person. Nick, and then Mr. Brown.
Just to follow on from what Barry's asking, have any of you given any thought to what elements might be involved in post-legislative scrutiny arrangements were we to recommend such a thing?
For RIPA or for any bill that might come out of this?
For this bill, if there is to be one at all.
Well, I have to say that I watched the Interception Commissioner's evidence with great interest, and I made a number of points about the Interception Commissioner's role in my written evidence, and it seemed to me that the Commissioner's evidence vindicated a large number of the criticisms which I made. It doesn't appear to me that the current Commissioner is exercising an effective and credible regime. I don't know what impression he made on you. So I think that I would like to see a much closer connection between Parliament and the actual oversight and continuous review of any internet surveillance legislation. And in particular, in my written evidence, I made reference to a recent European Parliament report which did a comparative analysis of different countries and how they have set up their oversight machinery and the relationship to Parliament. And the UK did particularly poorly in that. And the European report was very critical of, shall we say, too close links between the oversight role and the executive. And that seems to me a syndrome which we indeed have.
Much. Well, we're coming to well, we covered it right now, then, oversight. Carry on, Lord Strasbourg.
No, I was going to ask, might we get a copy of that European report?
There's a URL provided in my written evidence, but
Thank
I'm
you.
happy to point you at it if you wish.
Chairman, could I just ask if any of the others have anything to add to? I mean, this is uncharted territory, we know that. Is there anything that any of you could add to that?
Paul, I'll take you on number 9 now, because we're on to oversight.
You are? Well, I'm just trying the oversight aspect of it. Post-legislative scrutiny. I guess.
No, if there's nothing to say, then let's
Nothing
Lord
to say.
Strasbourg. Since we're on oversight, Lord Strasbourger, and then we'll go back to Mr. Ellis.
Mr. Bowden has argued for a revamped oversight system with a single, unified surveillance commissioner reporting to Parliament. What powers and resources would this new commission need to assure you that the use of the legislation was being properly scrutinised and that the necessity and proportionality of requests was being rigorously tested?
Well, I've had the opportunity to do some comparative analysis with the French system and the German system. And I think there are elements from both which would be worth consideration by this committee. The French system have essentially a commission. There is no, as it were, single commissioner with complete authority over that commission. The commission has taken on itself the past few years, without statutory authority, but with the consent of everyone concerned, the approval of communications data access for counter-terrorism cases. And it appears to be able to do that with a measure of independence and cost efficiency, which doesn't fully satisfy what I would like to see in terms of prior judicial authorization. But it seems to be much more credible, frankly, than the oversight machinery we have at the moment. So they do, for example, emergency authorization of interception warrants within 1 hour with independence. And they also have arranged 50,000 communication data access authorizations for counter-terrorism purposes. They've arranged prior authorization of each and every one of those. And I think the fully desirable position, I think, would be independent judicial authorization through a magistrate, as, for example, now happens with local authorities. And I think that could be streamlined and made fairly cost-effective. Looking at the German system, the G10 Commission, that is also a mixed commission, but primarily parliamentarians actually sitting on that. And I think that there would be room for maybe more stakeholders to be involved. I do question the way in which the interception and other commissioners are constrained to be former senior legal figures presently. It seems to me there is a case for allowing people at professorial level with a technical background, but also other qualifications and attributes to occupy that role. Because, frankly, it doesn't appear to me that figures who, at least those figures who get appointed to the role of Interception Commissioner, have been able to understand the technical position, if I can put it bluntly. There is simply no evidence in the way they write reports, in the matters they've covered, in what they've said in evidence, that they are in fact au fait with what is technically involved.
Okay, thank you very much. We'll go back to Mr. Ellis.
Thank you, Lord Chairman. So, can we look at the data from overseas, gentlemen? I noticed that both Dr. Hussain and Mr. Bowden have questioned whether overseas CSPs will accept this legislation because it imposes legal obligations on them. And they're outside the jurisdiction. Now, the Home Office has argued that RIPA already does this, and doubtless there are many other provisions on the statute book. Some of them have been on there for many years, which also tend to impose obligations on others outside of the jurisdiction. This bill will simply extend those obligations to the retention of further data. Do you agree with that, Mr. Davis, for example?
I mean, I guess I don't know, other than if I was approached by an overseas government, I'd have to be approached via the channels that we have with our own government. And
but do you think that there will be a problem with companies, organisations outside of the jurisdiction accepting this English legislation?
I would guess, why would they want to accept it?
Dr. Hussain?
We've consulted with almost all the large providers, and because the Home Office told us exactly the same thing, which is foreign CSPs already fall under RIPA, and I was surprised because I thought I must have been wrong for the past 12 years. And when I went to these foreign providers, some of them laughed in response, again saying that's just not true.
So,
and then when we looked into it, the reason the Home Office would say that is because that would mean, if it wasn't the case that the foreign CSPs were under RIPA...
Order, I need to suspend. There's a division in the Commons. We'll reconvene as soon as we're quorate with members of the Commons. So the faster you're back, the faster we can continue.
Absolutely.
Order. Right, order. We're back in session again, back on the record. Now, I'd be grateful, Dr. Hussain, if you can remember Mr. Ellis's question, if you'd start from the beginning and answering it.
I do. The Home Office states that foreign service providers fall under RIPA because it has to. Otherwise, every request that the Home Office has placed under, say, Google or Facebook would be illegal or beyond the law. The situation for foreign service providers is that they voluntarily reply to some requests. They do not reply to all requests. They reply voluntarily to some requests. Their preference would be that their request would go through the mutual legal assistance treaties. Because the challenge they face, particularly those who are based in the United States, is that the standard of law in the United States is far higher than the standard of law, say, in the United Kingdom. And so how can
Are you a lawyer?
I'm not a lawyer, but I've consulted with all the lawyers I could on this matter. I've consulted with lawyers who are actually fighting this case in the Supreme Court right now about the National Security Agency and the Bush administration and the Obama administration.
So is it your position, Dr. Hussain, that the Home Office is lying about?
I'm not saying they're lying. I'm saying that they have to say that in order for their requests to be compliant with RIPA.
So, no, hold on, I'm going to press you on this, because you are effectively saying the Home Office are lying, aren't you?
I'm not saying the Home
You're
Office-
saying that they're saying one thing and mean another thing.
I'm not saying they're meaning anything else. I'm saying that they have to say that in order to be compliant with RIPA with these requests.
Right.
Otherwise, they're making RIPA requests against an organization that they cannot make requests against.
Okay. So there are plenty of examples, are there not, of cross-jurisdictional cooperation
Yes.
in many different spheres, not only in this sphere, but in many different spheres. For example, the United States frequently imposes obligations, does it not, on other countries that have to comply with, at least if they want to do business in the United States. Is that not the case?
Yes, that is the case.
So it's becoming increasingly common for countries to enact legislation that imposes a burden on other countries. Why don't you see that working in this case?
I believe that this Parliament can choose to pass such a legislation. I just do not believe that the foreign providers will look upon that favorably or comply.
If the Home Office were to say, and please, gentlemen, if you would like to join in, if the Home Office is saying to the contrary, they're being told something different to
By who?
what you're being told by providers, what would you say about that?
In the discussions we've had with providers, they say they respond to requests on a voluntary basis.
But what I'm saying is the Home Office's position is that providers will cooperate with them, and therefore they don't envisage this problem that you're concerned about. Do you have any reason to doubt that or refute
My
it?
point is that they cooperate voluntarily.
Yes, can I pursue this point, Dr. Hussain? You said initially that when you took this up with the foreign service providers, they just laughed at the concept. Now, did you find any inconsistency between the views of the London head office of those American providers and the American head office?
No, I did not. I did not see any difference between the London office or the foreign offices of these providers.
Well, the head office in the
office.
States. Right, that's interesting because I think we were getting suggestions that the evidence we got from our CSPs in the United Kingdom that there would be potential difficulties with this was not the case because the Home Office had assurances from the HQ in California. Can you cast any light on that?
The conversations we've had with senior legal officials in the U.S. is that they want to help. They really do. But once you start placing legal obligations, if the United Kingdom does it, then the Saudi Arabian government will do it. How do you pick and choose between governments? And it creates an awkward environment. So therefore, that's why they prefer a voluntary arrangement where they pick and choose which requests they respond to. And second, they're far more favorable towards the legal route, the pure legal route, which is compliant with law in the requesting country and the requested country. In the United States, they would like to see it go through the mutual legal assistance treaties that require a request to go through the courts in the United States.
Ms. Cohen? Do you have
It's an observation which I could perhaps put to Dr. Hussain. When we were talking to the Metropolitan Police, it was clear that the biggest of the foreign service providers most certainly picked and chose. I mean, that they, for example, cooperated unhesitatingly with murder or terrorism. Certain other forms, no, if they couldn't be, if they didn't feel that it was particularly appropriate. What would, if this legislation went through, what effect would, I mean, obviously our Home Office hope that it will stop them picking and choosing, that they will decide to cooperate fully with whatever request. What would your view be on that?
My opinion is that it's going to lead to, well, we're on a collision course. That is, they're relatively happy with the voluntary regime. The moment there are arduous provisions placed on these companies to do something based on the decision of a parliament in another jurisdiction, they're going to start saying, we will not reply, we will not respond. So that's why I'm very surprised that the Home Office is choosing to rock the boat, let's say. I do not like the voluntary arrangement at all. I believe in the rule of law. I believe requests must follow some framework established by Parliament. But the Home Office is rocking the boat over this voluntary, slightly dodgy legal arrangement, or not necessarily strong legally bound arrangement.
So anyone else? Because we've been confused.
I do have a slightly different observations to make. I've referred to a problem in my written evidence which I call schizoid jurisdiction. And this occurs when an international provider decides to respond, say, to a RIPA Part 1, Chapter 2 request or demand for communications data. And they fulfill this through their local office, and they give this to the local law enforcement agency, exactly as would occur as with a domestic communication service provider. But when a data subject, an individual, makes a request to exercise their privacy or data protection rights, then the company will say, oh no, I'm sorry, that data was transferred to the United States and now falls under something like the Safe Harbor Agreement, where in practice the individual's rights are much less. So I'm a little bit confused by this language of voluntarily complying. I mean, I think now all reputable communication providers, whether they're international or domestic, respond to RIPA Part 1, Chapter 2 demands for communications data. So it isn't voluntary in that sense. What the question that Gus, I think, correctly raised is it's not just the UK that's going to be wanting this. There's going to be Indonesia, there's going to be India, there's going to be regional powers. And there are all the time a few big global providers. So,
order, we have to suspend again. There's another. No. Hang on.
Abandoned. I can hear the bell.
Oh, I can hear the bell, the light green.
Yeah. You see the comments?
Yeah, so I think we have a division in the Commons. You know, there's not flashing on our screen. Can you open the door to hear the bell?
No, Chair, unfortunately.
All right.
The bell definitely went off.
She's just checking.
Okay, we'll send someone to check, but we'll continue until I get an authoritative verdict that there's division.
So if I could just pursue this and try and break down two aspects in answer to Mr. Ellis's questions. When we talk about a foreign provider complying, what exactly do we mean? Do we mean that they will be keeping data types which they do not ordinarily keep in response to some voluntary request from the UK government? Or, in particular, do we mean that they'll be responding to requests to the so-called filter, that somehow they'll provide an interface into their systems, typically in the United States, to allow data mining of very general kinds within their own body of data? That seems to me extraordinarily unlikely that that will occur. So then, to move back to the first question, whether any international company will retain data types that they would not ordinarily retain, that also seems to me fairly dubious. I'd be surprised if any general counsel of a US-based company has given such an assurance to the Home Office. I would find that surprising.
Thank you very much. Can we move on? Lord Jones.
Lord Chairman, gentlemen, this is on third-party provisions, and there has been criticism, and I think Dr. Hussain has made some criticism, perhaps as recently as July. The question is, some of you have expressed considerable concern about the proposal to ask UK CSPs to collect third-party data, and the Home Office has not conceded that it might be necessary to write assurances into the legislation. One, that the original data holder would always be contacted first, and two, that UK CSPs would not be asked to store or release encrypted data. If these assurances had legislative backing, would they allay your concerns?
Whoever wants to go first. Mr. Davis.
I'm not really sure if it makes any difference whether it has legislative backing or not, because the reality is that it's a lot easier for this third-party data to be sourced from the third party rather than from the actual ISPs themselves. But I would imagine, and I don't have numbers, but a vast proportion of this third-party data will be encrypted. And so in order to be able to access it, you know, we're into that debate about the technical feasibilities of it. So, and I recognise that in the written evidence there are a lot of different, you know, level playing field issues, legal and commercial issues, but from my point of view, it's the technical practicality of it.
Anyone else? Yes, Dr. Hussain?
It's still a form of coercion to tell a foreign provider, comply with our requests or else your client's data will be stored by a third party in a foreign jurisdiction. You're putting the provider in the middle of a rock and a hard place. And that's the intention of this very clause, or this approach. It is comply with us or we will make sure there's a domestic pool of the data of your users. And that's highly problematic. I think there is a way through this. It's not for me to recommend policy, but I do believe that a targeted, because what your question seems to be pointing to is that there are very specific targets that the authorities in this country want to know more information about. Very specific, whether it's internet places or individuals. And that allows for the type of regime that Mr. Bowden talks about, which is a targeted preservation regime, which is you can ask for a very, like a national security level concern that ISPs in this country would monitor traffic to a specific provider, but in a very specific circumstance under a very specific authorization. There's nothing, while there are issues of debate around that, I believe that that's a more proportionate response than going to all the foreign providers saying, do what we say or else.
The Home Office, I think, would say to that point, that's all very well if it's an ongoing operation, you've got a potential terrorist X, can we please preserve everything on this guy until we've got enough evidence. That's a different situation from when they come across terrorist Y, and then they say, can we see what you've got, and we haven't been storing anything on them. So you don't provide the whole answer.
I'm actually addressing one slightly different aspect to that, which is imagine there is a social network for terrorists based in Malaysia, a service provider that runs a social network for terrorists, and we want to be able to monitor all the terrorist activity, the terrorist users that may be based in the United Kingdom. There would be a way to have targeted preservation of traffic going to that specific resource. That's very different than requiring it of all resources on a do what we say or else regime.
Anyone else then?
Well, I think I agree and develop what Dr. Hussain has said, that I think what we are asking is for law enforcement to look at their task progressively in a different way, which is instead of assuming that somehow there can be blanket recording of this data about the entire population, it's going to be more of a question of beginning, as it were, with the threads that are available and then developing an investigation. So you would widen the circle of interest and cumulatively broaden the use of the powers of preservation until you're in a position to acquire the evidence and intelligence you need. Now, this could be something of an upheaval for the way law enforcement has proceeded so far, and I think this must be accepted. But honestly, we have to give data preservation a chance. We have to develop a credible regime with which law enforcement can live to try and make this work before we go to the stage of saying that somehow it's acceptable to perform this blanket preservation on everybody in the entire country. I'll offer perhaps a slightly dramatic example of how far we've come in 10, 15 years. In communist Albania, the secret police, the Sigurini of communist Albania, used to have a ritual where every year they would require every citizen to come and have a chat with their secret police. And each person would be required to cooperate in building what was called a biography with an FI. And this was, as it were, a personal dossier in which they would have to record all of their social relationships, social contacts, main meetings that had happened to them over the previous year. In terms of the way we live our lives now, and particularly social relationships are expressed through the internet, we're effectively allowing the Home Office to build a biography on everybody in the country, on their pattern of social relationships, on the fabric of everyday life. And it seems to me, just taking a step back, it is extraordinary that we've got to this situation at all, and we're even contemplating it, as opposed to a targeted.
Mr. Whittaker, then I'll go to Lord
Mr.
Armstrong.
Byrne, can you honestly believe for 1 minute that we are talking about an Albania situation here in the UK? I mean, and we're not talking about building a profile, we're talking about securely storing information. The profile building, if you will be in the access and the safeguards putting in place to get that access. So I think that's a little bit scaremongering from that point of view.
With respect, not. If one looks at the testimony of William Binney, who I also referred to in my written evidence, and whose video to a hacker conference in New York was available online, William Binney was a senior National Security Agency engineer who has now become a whistleblower, objecting to these types of practices conducted in the US. And the technology that he, as a senior engineer, was building 10 years ago was in fact precisely an automated biography file. It was not merely a question of leaving this data passively in place. And there's a direct correspondence between the sort of machinery that he engineered 10 years ago and what is proposed in the filter. So, of course, it depends exactly how the filter is going to be implemented and what lies behind the filter. But I don't think it's correct to sort of imagine that somehow these are, as it were, passive piles of data sitting around. And even if that was the case, there's certainly case law at the European the European Court of Human Rights to show that blanket retention of this kind of data, particularly if it's going to be used for pattern analysis and traffic analysis, is well beyond what the European Court has tolerated so far.
Thank you. Lord Arms. Oh, sorry, Mr. Davis, briefly.
Kidding ourselves if we think we can keep everything secure. You've only got to look at the recent case of the chap who hacked into the Pentagon computers from his back bedroom.
Yes. We need to move on. Lord Armstrong. Yeah.
Yes, thank you. This changing the subject to the definitions of subscriber data, user data and traffic data, as you might say, the RIPA definitions. The Home Office said, when we saw them the other day, that it might be sensible to reconsider these definitions in order to allay fears that information not traditionally considered as data could be caught by the legislation. And what I wonder is whether you think that narrower definitions of communications data or revision of the existing communications would allay some of your fears about the scope of this bill.
Would you care to suggest what the narrower definition is? Because I'm not sure.
We're asking you the questions.
Well, perhaps one example may be on subscriber data. Because at the moment, subscriber data is everything else that remains, which could be, if one was on Facebook, up to about 78 different items. And subscriber data has expanded dramatically since the year 2000, when it was my name, address, my mobile phone number. Now it could be everything that's on my iPhone, if I had one. So that's just one example, possibly, theoretically, where one could say subscriber data in future will only be X, Y, Z. Perhaps Dr. Hussain, if you want, or Mr. Bowden.
I did watch some of the recent evidence sessions where this question was also discussed, and particularly the sort of Facebook issue of, what is your favourite colour or favourite XYZ could technically qualify as subscriber data. So I think it would be a modest and useful restriction to ensure, for example, that that was not possible. But the way in which we've arrived at the current definitions of the three main categories, it should be borne in mind, goes back to 2000, when RIPA was being debated in the House of Lords, and essentially the House of Lords lost confidence that the Home Office knew what they were doing, and the definitions of communications data had to be rewritten with some urgency between, I think, second reading and report stage. And so Industry had some input into that, but I don't think there was any much civil liberties input into that. So the definitions we have today have various anomalies. For example, the record of itemized phone calls that one makes, as it were, outbound from one's phone currently falls, if one looks at the code of practice, into the category of use data, whereas incoming phone calls, which of course the individual doesn't necessarily see, that falls under traffic data. But their impact on privacy is similar. So I think there would be scope for rationalizing the definitions to try, as it were, reach some equivalence in their privacy impact, which is the correct way of analysing this, in my view. And most of all, I think one should try and separate the concept of traffic data in a broad sense from subscriber data. Subscriber data is essentially static and deals with the identification of people. Traffic data deals with your social relationships and what you're interested in, what's really going on inside your head. And this is intrinsically far more privacy sensitive and should be dealt with, in my view, much more under the rubric of interception, because the impact on privacy is analogous.
Thank you. Mr. Walker, you. Yep.
Yes, while I see that actually clarifying the characterization of these data types would be extremely useful from a legal perspective, there is a considerable technical problem that these classes of data are very intimately mixed, actually, in the communications themselves. To use Mr. Bowden's example, when it comes to mobile phone calls, the actual mechanism by which the text messages we are used to sending and receiving on our mobile phones pass from one handset to another uses the same signalling mechanism that is used for actually ringing someone up. So again, separate in terms of actually capturing that data, logging that data, separating them out as part of a capture process is going to be extremely hard, especially given the vast proliferation of protocols in existence.
Lord Armstrong?
No, I think that really answers the question.
Okay, excellent. Mr. Whittaker?
Yes, thank you.
Chair. Dr. Hussain and indeed Mr. Bowden, today you've alluded and advocated a warrant system in the past, and I think you said that it would apply to all agencies wishing to access the comms data. As a committee, we have heard, though, and taken evidence that the current SPOC scenario and authorising officer system is actually much more expert and rigorous than a magistrate necessarily would be in a warrant system. Do you accept that might be the case?
So, in my observation, SPOCs do play a useful role. And if one looks again at the current code of practice on acquisition of traffic data, the various roles of SPOCs include giving advice and trying to ensure consistency within a particular organisation. And I think all of that should continue and is necessary. I think the problem is one of the principle of independence and the authorisation to access this data, which, as we've covered, some of which can be highly privacy intrusive, as intrusive, I would say, as interception. This should be done through prior judicial scrutiny. Now, I don't think it's going to work to somehow imagine that one can keep a system which would assign these authorizations to some random magistrate. I think we should consider, together with a reformation of RIPA, how we can organize essentially a specialist magistracy to triage and deal with these in an organized and efficient way, and preferably to try and put interception of communications also on a basis of prior judicial scrutiny. There will be the opportunity to do 2 for 1 and to have the same sorts of work dealt with by the same sorts of magistrate. But they would obviously be dealing at different levels of justification or suspicion. So to justify interception, you would need a more serious and more detailed case than to initiate the preservation of certain sorts of communication data. I did note... Yes. Yes.
Are you referring to the Secretary of State warrant system?
Yes, I am. I'm personally not happy with the Secretary of State system for a number of reasons, but I won't digress that way. But I would just take the opportunity to clarify that the opportunity to consolidate both, ideally. I did notice, rereading the Code of Practice, that there is a curious self-imposed limitation in the way in which Part 1, Chapter 2 authorizations for communications data are currently applied. which is if a law enforcement agency wants to secure data about the future and to record data which would not perhaps otherwise be recorded about future communications, the Code of Practice says that can only be done for 1 month. And this is very peculiar. There's no statutory reason why it should be limited, or human rights reason why that should be limited to 1 month. One might think it's almost the Home Office trying to, as it were, not use preservation very much because they regard retention as such a valuable tool when they don't want to upset, as it were, the status quo which accepts the retention regime. But if one moved to a prospective, positive, targeted preservation regime, then obviously you would want to authorise the future retention of data for a longer period.
So just for clarity, then, you're talking mainly about the Secretary of State system. What about on a run-of-the-mill Spock system, where I think you were advocating earlier on that actually we should have a warrant system?
Well, I mean, a warrant, one has to say what one means by a warrant, because at the moment for interception, a warrant is issued by the Secretary of State, and I do not favour that approach. I'm talking about a warrant, as it were, issued by a judge or a magistrate.
Yeah, but I'm particularly asking about the system we currently have in place for the accessibility to the data on a much lower level.
Yes. So I think, as I set out in the written evidence, my own position on this is that providing subscriber data was limited in the way the chairman suggested to quite narrowly defined types of what we would ordinarily consider subscriber data. I would be content for SPOCs to authorise access to subscriber data. But I would say that anything that is traffic data or usage data, which is intrinsically far more privacy sensitive, should require a magistrate.
I'm highly sympathetic to the SPOC system as an integrity check. And I believe it's a very good stopgap measure for that. But I do not believe it is sufficient for a true test of necessity and proportionality. And that's why you need independent oversight. The reason we all like the SPOC system is because the SPOCs are trained. They have knowledge about the technology and about the law. And the reason we're currently suspicious of magistrates and judiciary is that we doubt that they have the capability. That I find is very worrying. If we are concerned that the judges in this country are incapable of understanding the complexity of these types of requests, that's something that needs to be fixed beyond the scope of this law.
Well, we're not talking about the judges, we're talking about magistrates.
And even so, we would still need to address that issue. Because it already exists under the Protection of Freedoms Act that magistrates are involved in some authorizations, particularly from local councils and whatnot. If we believe they lack rigor to respond to these types of requests, well, how come we authorize them to do so under the Protection of Freedoms Act? I believe that our judiciary and the magistrates may need training at the same level that SPOCs do. I think SPOCs are a good example of what happens when you train people appropriately.
So can I just get you to clarify then why you feel that a warrant system needs to be in place above the SPOC system, which appears to be working quite well?
The SPOC system may notice errors and may notice some abuses, but the SPOCs look as to whether something is lawful. They are not necessarily the judges, sorry, lack of a better term, the arbiters of what is necessary and proportionate in a democratic society. That is what that balancing test between the public interest and individual liberties has always resided with an independent body.
Would it help if we put the SPOC on a statutory footing, like we do with those designated senior officers, for example? Do you think that would help the situation?
I do not believe it's sufficiently independent. And I think, as Mr. Bowden was pointing out, communications traffic data is becoming even more sensitive than communications content. I think one opportunity for this committee is to start having a debate about why is it we protect communications content to such a degree, but not highly invasive data, mineable communications data, and why are they any different? And I believe once we start having that debate, we'll start asking why is it we require a warrant for content but not for communications data.
Thank you very much, Dr. Sanders. We're in interesting territory, and I think the committee generally picked up that the best trained SPOCs are very good, and that system seems to be working. Yes. The question is what level of oversight of the SPOCs and the type of oversight, whether judicial or commissioner or whatever, is required. That's what the committee will be agonising over. So, Mr. Davis, Mr. Bowden.
I just wanted to make the point that looking at the evidence the committee's received and my own researches over several years, and I don't know what evidence the committee has received in private, but it's still not clear to me what actual criteria SPOCs use to determine what is necessary and proportionate. And indeed, it's not clear what criteria the Commissioner uses, despite his evidence. If one actually wants to get down to concrete cases and say, for a mugging, for a murder, will 5,000 people's data be accessed, or 50,000 people's data be accessed? One needs to have some concrete yardstick of really what is being done. And I have no idea. I don't know if the committee has managed to unearth that sort of practical information. I noted the Commissioner, Interception Commissioner, in his evidence said he doesn't have any difficulty deciding which is which. And I suggest this somehow would suggest this means that all SPOCs are somehow operating with some sort of magical sense of pre-established harmony, which I find rather hard to believe. I would like to know concretely what is considered necessary and proportionate. And I don't think with SPOCs they have the independence to really do that in the same way that a magistrate would.
It's an interesting point which the committee will be exploring. Mr. Davis.
Just to add, we get RIPA requests, but we don't get very many. So maybe 1 or 2 a year, actually. But by and large, the quality of what we've been asked to do seems to be acceptable, and they're genuine, right requests. What I did pick up, though, in the written submissions, the written evidence, was the Big Brother Watch submission regarding the variations in the way these requests are made. And Kent Police, in 2 years, made 7,664 requests for data, with 3,237 of those rejected internally, and compared with Merseyside, who made about 30,000 requests, and only 500 of them were rejected. And it does make me raise an eyebrow a little and ask, is the oversight really overseen?
That's an interesting question, which I personally don't have the answer at this precise moment. Do any other colleagues, Baroness Cohen?
Could I just sort out in my mind that Mr. Burden divides subscriber data from traffic data? Well, we all do that. But in terms of subscriber data, you'd be perfectly happy with a SPOC.
I think with the current code of practice, one has to bear in mind the code of practice does not exclude other interpretations. And in fact, I wanted to draw attention to this. When reference was made a couple of evidence sessions ago to the way in which the code of practice, shall we say, takes care of these things, if one reads the code of practice, it says the sorts of data falling within this category include. So the code of practice by itself does not exclude far-fetched or over-expansive interpretation. So I think it is useful and necessary to have very precise definitions in primary legislation which would exclude, shall I say, far-fetched interpretation.
If we could get the subscriber data definition satisfactory, you wouldn't feel that needed a magistrate. You'd be happy with the SPOC doing that.
That is
so I don't mean to put words in your mouth. I'm trying to check.
With other qualifications, broadly, that is my position, because I think that represents something which is doable, and that would have to be done, in my opinion, with a move towards a preservation methodology by law enforcement.
And I think Dr. Hussain is going to say, provided someone is second-guessing necessary and proportionate.
That's my next question. That even for subscriber data,
I
still
understand
feel
that the mood in this discourse has moved that subscriber data is not as valuable. But as a privacy advocate, I have to remind people that the protection of journalists, protection of journalistic sources, protection of leaks sources, the revelation of subscriber information will reveal all of that. And so even that needs a test of some sort, and an independent test of some sort.
Thank you very much. We are running late and we must really push on. Mr. Mosley.
We've heard diametrically opposed views on the filter. On the one hand, I know, Mr. Bowden, you've described it as a hyper-Orwellian menace. And the Home Office would let us believe it's a way of protecting people's privacy by eliminating people who they're not interested in. I guess it could be either, depending on how it's used. So the oversight and the control of the filter is going to be incredibly important. What kind of oversight do you think the filter should have to ensure protection of people's privacy?
Well, perhaps it won't surprise the committee to say that I don't think the filter should be built under any circumstances for domestic surveillance. It's understood that GCHQ have had these sorts of capabilities for many years for international communications, but I simply think that the kind of capabilities described in the filter are intrinsically incompatible with a modern democratic society. I don't, I mean, on the basis of blanket data retention, you understand. If we're talking about preservation of data about designated targets, where each designated target, there is a reason, there is a justification, even if that is a reasonable belief or a reasonable suspicion, but still a far smaller 1% of data than one would be talking about on the basis of blanket retention. But anything to do with the filter, so-called filter, I would call it data mining, of particularly traffic data, which is so prejudicial to private and intimate life. I think safeguards and oversight are irrelevant. I just don't think it should be done in a democracy.
Any other wish to comment?
I agree.
Okay, well, turn to you, Mr. Davis, then. If this filter does come in, a company like yours will have to interact with the filter and use a standard data format. I know we've been told about RDHI, etc. As a business, would that cause you any problems at all?
There's almost certainly going to be an overhead with running and interfacing it, aside from my concerns about whether it should be there or not in the first place. But I think that the biggest problem we would have as a business, and really I'm answering question 11 here as well, is that the amount of effort that we would have to put in the first place to setting it up. I'll give you an example. Well, we are, as a business, we're not a small ISP anymore. We're about £40 million turnover. We have a couple of hundred staff, and maybe 40 of those people are engineers. But most of the engineers work on day-to-day customer-facing stuff, solving problems. And the real core of our team who would have to work on this kind of stuff, we've only got 6 people, and they are network engineers, systems engineers, and applications engineers. We have some deep packet inspection equipment, which we installed 2 or 3 years ago to protect our customers' networks from surges in traffic. And we actually had to have a couple of engineers working for about 3 to 6 months on that, full-time, with an external contractor to install it. So for us, that was there's a business case for doing it. Now, we've got 6 engineers. Smaller ISPs may only have 6 or 10 engineers to do what we have 40 or 50 engineers, but it would still take the same amount of effort. So the smaller the ISP, the more disruption and harm it takes. And it's not a great leap of the imagination for me to believe that if I was having to implement the systems to interface to the filter, then I'm probably looking at half or 2/3 of my development resource, which I then would not be able to have working on my next products, bringing the business into the 21st century with virtualization and the cloud, which every ISP in the country is racing to try and bring out new products to keep up with the technology, and it really would have a big impact.
Right. Baroness Cohen?
I think that was the answer to my question.
On harming UK business?
Yes.
Okay. Any other outstanding points? I think we've concluded our evidence session, gentlemen. Very grateful. Unless you have any other concluding remarks to make. No,
if I could just,
yes.
One sentence, please do not drop the issue of notification. I'll remind you that of the case in Poole of the family that was placed under surveillance by the council because of catchment areas. The only way the family was notified of the fact that they were under surveillance was because the the council accidentally told them.
Yep.
People need to be informed of when they are placed under surveillance, when it is no longer relevant to the investigation or harms any judicial process.
That's a legitimate point. I curtailed our discussions today because we're running out of time, but we're grateful to you, in particular, Dr. Hussain, for that evidence on notification, which we're considering in written form. And thank you for drawing attention to it. Gentlemen, we're very grateful. Thank you very much for coming here today. Thank you for your written submissions initially, which have provoked us into bringing you forward to give oral evidence. Thank you very much.
Thank you.
Right, I'm going to go to the loo. So the committee will adjourn for 3 minutes while we get the next group of witnesses in. Order, order. We're now in session again. Welcome to the afternoon session. I'm sorry we're running slightly late, gentlemen, but you're very welcome here this afternoon. Now, whilst we all know who you are, for the record, I'd be very grateful if you would just say who you are and who you represent. So I'm Mr. Higgins.
Detective Superintendent Steve Higgins. I represent the National Policing Improvement Agency. I also sit on the ACPO Data Communications Group Executive.
Thank you very much. Sir Peter.
Peter Fahey and Chief Constable of Greater Manchester Police.
Thank you very much.
Peter Davies, Chief Executive Officer of the Child Exploitation Online Protection Centre.
Mr. Lyon.
I'm Alan Lyon. I'm a Detective Superintendent in Greater Manchester Police and the Senior Responsible Officer for Communications Data.
Thank you very much. Mr. Stevens.
David Stevenson, Police Service Northern Ireland, Block Manager, also the Secretary to the Data Communications Evidence Subgroup.
Excellent. Thank you very much. We have a lot of questions to get through in the time. We'll probably run slightly late with you as well. Don't everyone feel you need to answer every single question. If you feel it's been covered by a colleague, then we move on. Can we start with Mr. Hubbard?
Thank you, Lord Chairman. Can I start off with an apology to Mr. Davies for not having been with him just before this another select committee, but as well as myself trying to be in two places at once. The government has identified two specific types of data which it wants the UK CSPs retain. It announced this at a session last week. These are data relating to allocation of IP addresses and weblog data, the information up to the first slash. Are you aware of a data gap existing specifically in these areas, which you think needs to be addressed so that your organisations can perform better?
Certainly, I am, as Chief Constable, in an area with a serious problem of organised crime in particular. I think the way I would describe this, that often when you're carrying out these sorts of investigations, what you're trying to prove is associations. Sometimes there's obviously an association between an offender and a place, or an offender and a victim. But often it's associations between different groups of criminals. So, for instance, if you arrest, say, a foot soldier, in effect, who's got, is delivering drugs, and you're trying to prove an association and try to capture the higher level drug dealer, then clearly you're trying to prove that association. And up to now, we've been able to use some of the more readily available communication data to do that. But the fact is, we are seeing that the criminals are realising that, moving to some of the new technologies and some of the new platforms. And really what we see is obviously, as most people do, an explosion in those new technologies, the new apps. And clearly we are very fearful that we will quickly lose the capability to actually do that. But we already have got specific examples of them using some of those new platforms to defeat us.
So, Peter, the Home Office said last week that the two main issues were IP addresses and weblog data. Are you saying you disagree that actually those two wouldn't resolve it? That what you need is...
they absolutely would resolve it in terms of starting to capture some of the other forms of communication that we know that those criminals are starting to use. And again, I know you accept this point. It's not about the content of those communications. It is the fact that you are communicating with this other person, which then starts to create the relationship, and then we can use other data then to prove the conspiracy.
And in your experience, do you have a sense as to how important each of those two categories are? Which one covers more of the gap?
No, I mean, I think they are both really equally responsible, equally important, and equally responsible in terms of crime investigation and proving that case. But it's fair to say that we are very aware of the way that the technology is developing, and therefore, clearly we need to try and maintain that capability and trying to make sure the legislation is framed that it maintains that capability for the months and years.
One last question, Peter, and then I'll bring the rest of you in. If the legislation were just to specifically restore those two capacities, that then would satisfy the majority of your concerns about the data gap. Is that right?
I think it would presently. I think we've got to be clear. I think, as everybody is, that trying to forecast how technology will develop is very difficult. And I think what is concerning us is that we are continuing to see people offer ways around some of the existing technologies and some of the existing techniques that we use. So I think I want to be realistic with the committee to say clearly, when you look at the way that some of these people are developing, when you see what is being offered, and of course when it's on the net it's available internationally, then clearly, you know, I wouldn't want to be able to say that just if you did this, you know, if you provided this and the legislation went through, then suddenly the problem would be solved for so many years hence. I don't think anybody could say that.
Okay, we'll solve the current one. Mr. Davies.
Yes, thank you. As I know you're aware, we approach this from a slightly different angle. Some of what we deal with at CEOP is serious organised crime. Some of it is more internet dependent than others, but we also deal with protecting children who are vulnerable and at risk. And often the only opportunity to identify them is through communications data. I don't think I can tell you which of the two options you give us are the most prevalent in terms of IP addresses and weblog data. But I think what needs to be acknowledged is the need not to frame legislation just about to meet the needs of today, but to frame legislation that is capable of dealing with the developments in technology of tomorrow. From my point of view, our type of offenders, our predatory paedophiles online are among the most sophisticated there are.
I'm sorry, Mr. Davies, but how on earth can we frame legislation to meet the needs of tomorrow if we haven't a clue what those things are going to be?
I think the fundamental things about communications data don't change. They are a transfer of data between point A and point B, the opportunity to identify point A and point B, and the opportunity, having done so, to understand what point A as an account is doing, provided the legislation enables us to do that. Those are pretty much the same issues to do with comms data.
With respect, could I disagree on one point? I sat on REPA in the year 2000, and in the year 2000 my mobile phone would give you some basic subscriber data and the number I called from and the number I called to. Now my mobile phone tracks me every inch of the way, and every 5 minutes you've got a record of where I am, and that's with most people. That is quite a fundamental change between what you're capable of doing now and what we envisaged in REPA in the year 2000. I'm merely suggesting to you that it is to make something future-proof means it's totally open-ended and maybe undemocratic.
I appreciate that. I think the other risk, and I know you'll probably explore this in the rest of your questions, the alternative risk is to make something that's adequate for the needs of today but does not help people protect the public or investigate the serious organised criminals of 2 to 3 years' time. I'm not sure that legislating after the fact on a pretty continual basis, which is what I think would actually be required to reflect the developments in technology, is a better option.
But thank you, Lord Chairman. I understand the point you're making, and future-proofing is an issue we've discussed a number of times in this committee, and how one does it, how one ensures parliamentary and democratic oversight. But can I just make sure that I understand, in terms of the current problem, as you say, you have a different set of issues you deal with. Would these two things solve the majority, or the vast majority, ideally, of your current problem as well as Sir Peter's current problem?
I think they solve the majority of our current problem, yes.
Thank you.
Is it the committee's view that what you want 99% of the time is who talked to whom, when, and possibly where? From where?
Yes, absolutely. It is, as I say, what is crucial to be able to approve associations. And particularly, as I say, in things like organised crime, to try and be able to capture the people further up the tree so that we're actually taking out the more serious offenders.
I think Baroness Cohen.
The other bit of the gap which the Home Office tell us they want to address is data from the overseas CSPs. We understand there are two sides to this problem. Some overseas providers don't retain the stuff at all, and some of them don't respond quickly, or indeed possibly at all. Is this a problem? Can you tell me, all of you, how much of a problem that is in your experience?
Again, it is a significant problem, and it is about the two things that you said. It is sometimes the time delay. There are certain providers that are pretty obstructive, that are uncooperative. Sometimes, a case we had around Christmas time, we're up against the custody clock, so we've arrested somebody, we're trying to do an investigation, we're trying to get enough evidence to get them charged. The international processes are just incredibly slow. So, it is obviously the issue that the internet is international. Often it's not just about us investigating, we then have to do disclosure, so it may be that we have to cover this particular line for the defence as well. The MLAT procedure, as it's called, we do find that it can be very slow, but it is also this issue that some providers are very cooperative, other providers are essentially obstructive and don't recognise the need. And therefore clearly it's important that this legislation, as far as it can, tries to cover that.
Any other colleagues? Yes.
Sorry if I...
Mr. Davis,
yes, I'm backing up what Sir Peter says. This isn't an overwhelming problem for us at the moment, but there's every indication, I think, that the ownership of the internet and therefore the location of communication service providers will migrate to other parts of the world. At the moment, where we have good relationships with US service providers, and they're subject to some legislation that places an obligation on them to report child sexual exploitation that happens on their networks, the situation's really good, or reasonably good. I think what we need to do is provide for the likelihood that it won't be as good when larger proportions of the internet are owned and operated overseas. It's a containable problem at the moment, but there's nothing about it that seems inherently stable, and it may well be a far bigger concern for my centre in the next year or 2 years.
Do you find that they answer all your requests, the cooperative ones, or do they pick and choose?
They answer the ones they can, when they can. I think the level of retention and responsiveness is different with each provider, and there are some providers that don't have a business need to retain the data and therefore don't retain it, and it's a pretty well articulated fact that roughly 25% of comms data requests currently don't come back with any information. The risk is that that might actually increase as a proportion quite substantially. I can go on to talk about what that means in practical terms.
I'm prodding because of your particular field that we were told by a previous witness that many overseas providers cooperated unhesitatingly if it was murder or terrorism. But harassment, internet bullying,
well,
they wouldn't bother.
We don't deal with harassment or internet
Right.
bullying. We put people onto those who do. We deal with serious and sexual exploitation of children by a variety of means. That generally galvanises people where
They cooperate where they can.
Yes.
Yep.
I think there's two key issues here. So one is the speed of the response. We have a system in the UK where automated solutions within the companies for the recovery of the data has significantly improved response times as against a manual process. And I think one of the benefits of the bill, were it to be passed, would be that it would potentially facilitate investment to enable that to take place. That's one of the issues. The other issue, of course, is that no matter how cooperative an overseas company may be, if they don't have a data retention policy or requirement in place in that particular jurisdiction, no matter whether it's MLAT or any other process, they simply cannot provide us with the information. So it's the ability to work with them and enable the retention of that data.
Okay, what about their willingness to disclose? You said, I think Mr. Davis said there's a 25% nil return. Is that all because they haven't got the data, or how much of that 25% is because they may have it, but they're not happy to disclose it? Because we haven't gone through legal means or whatever.
I think it's difficult to tell sometimes. It's slower to get disclosure for evidential purposes than for intelligence purposes. That's a distinction. Sometimes I think almost anything is technically possible if there is sufficient will to do it, and so the issue about what's technically possible crosses over into the issue about what people have the will to do. Each of our relationships with each of the service providers is different. They have different strengths, different areas for development. That's one of the frustrations of what we do, because if there was a consistent level of expectation about retention and access to this data, the extent to which we have to cultivate those individual relationships and, to some extent, hope for the best, would be significantly reduced.
Mr. Whitaker?
Can I just ask you, just on what you've said there, do you think making retention of third-party data over here from overseas, for example, is going to make any difference to that at all? Because we've heard very clear evidence that a lot of companies will actually encrypt the data, so it won't be able to be used here. So you'll still have to approach a company directly overseas yourselves using a different method.
I'm not so familiar with what companies will or won't do. I think it depends on what the expectation is placed on them by legislation. Let me be clear, the operational ideal probably for CEOP, but certainly for anybody involved in dealing with serious organised crime in any of its forms, would be that any level of communications data that's criminal related within the UK is capable of being researched to the point of identifying the point from which it left and the point at which it arrived, and proving the traffic between the 2 points. I'm not so familiar with that issue about third-party data, but we would want that to be held within the UK and accessible within the UK, because if that can't be provided, then it's probably lost. And for reasons I mentioned before, that's a significant risk in terms of our ability to use this information to protect people and pursue criminals.
You said they might cooperate depending on the legislation imposed on them, but we can pass in the United Kingdom legislation which we can impose on British companies or companies operating here. I mean, what expectation do you have that some of the American giants, and we all know what they are, companies that launched with maybe 100 billion turnover or value and are now a mere 50 billion turnover, why do you think those mega American companies are going to cooperate with UK law which doesn't technically and legally apply to them?
Well, I think number one, I mean, if Parliament passes that legislation, it's a pretty strong indication of the will of the country, and therefore there's got to be moral obligation upon them. I mean, clearly, all the time we deal with different commercial organisations who sometimes make decisions as to whether cooperate with policing and with law enforcement or not. So we have to cope with that in our day-to-day business. And I think it would be absolutely about sometimes levering public pressure onto some of those organisations, if necessary to name and shame, to say that, you know, we feel you should be cooperating and helping us in this form of law enforcement, in the same way as we might choose to shame a car park operator if they are not taking sensible precautions.
You mean shame Google, Facebook?
Well, if we need to do that, I mean, I think that if it was the sort of serious offending which the public feels very, very strongly about, then I think that absolutely, you know, we would need to do that, because
we had evidence in the previous session that that sort of heavy-handed approach was likely to diminish the voluntary cooperation you're currently getting.
Well, I think you normally, again, when you are talking to a car park operator or to a major supermarket or to a public house, you try and do it through cooperation, and generally that will work. But I think if you are faced with, as you say, one of these international organisations which was failing to cooperate, which was not following the legislation, then I think clearly we would be talking to the media, to some of our local politicians and national politicians to make them aware of that. And then clearly they may choose whether or not to apply pressure on them.
Okay. So Peter, before I move on to other colleagues, you said a United Kingdom government passes legislation. We symbolically show to, say, companies in America, we mean business. If Saudi Arabia passed the same sort of legislation and been one of the United States' major customers, wouldn't they feel under a moral obligation to supply it all to Saudi Arabia? Or China, or any other country which passes similar law?
Yeah, may well be, but you know, I still think that on the whole, the sort of issues we're dealing with here, the sort of investigations we're carrying out, there is a very high degree of public concern, and I don't believe that some of these commercial companies could ignore that degree of public concern. And clearly, issues which, on the face of it, to international companies, may not look that important, but perhaps are leading to serious consequences in this country for individuals. We know that the public and the media can be very concerned even about individual cases. Okay. And if it came across, as I say, that commercial organisation had made it more difficult to us to discover a perpetrator and that had led to a tragedy, then I don't think it would be terribly good for that particular organisation.
Mr Davis, do you want to comment?
I just wanted to add something. People have been very quick to identify implementation issues or enforcement issues around any of the proposed legislation. There's nothing wrong with that, but those issues of themselves I don't think are sufficient reason not to bother to legislate, particularly in the face of a very clear operational requirement.
I would like to ask what you all think about the Mutual Legal Assistance Treaty process, which is of course the legal alternative. The undoubted, agreed, negotiated legal alternative.
Yes.
How well does that work?
I think it works slowly. It certainly doesn't work in operational fast time, which is a proportion of the authorities that we actually require. And I really must hope that I have the opportunity to put a couple of cases to you which illustrate how direct and important some of this information is. it works with those countries with whom we have a mutual legal assistance treaty, but not necessarily not with those with whom we don't. And my centre is quite often in the position of having to go and ask for help in the absence of any such treaty. Generally, we do quite well at getting it, but it's pretty random. I wouldn't see the MLAT process as an alternative to the legislation as proposed.
Okay. Any other views? Mr. Ellis.
Thank you, Lord Chairman. So, Chief Constable, if I could come to you first of all. First of all, my condolences on the loss of 2 fine, brave police officers earlier this year. That case I know is active, but there was some reference at the time, at least in the media, and I think you've made some reference today, about issues within your force area of organised gang activity, and that being a serious problem.
Absolutely.
Would you agree with that?
Absolutely.
Now, do you have any observations in that context about the value of communications data?
Well, I certainly think that in terms of our current capability, communications data is absolutely vital to some of the successes that we've had, because it comes down to this issue of being able to try and prove associations. It's essentially that if you live in a nice area in Manchester and your house gets broken into and your car gets stolen, you're probably not aware that there is a connection there to organised crime who are creating the market for that vehicle and probably put the offenders up to actually committing that crime. And at the moment, communications data is absolutely enabling us to identify those sorts of associations and absolutely put people...
So you can prove an association with organised gangs in circumstances where otherwise you might not be able to do so, and where such an association is not transparent?
Absolutely. Absolutely. Because of the way that they are using communications data at the moment. But the situation is that clearly that when we arrest them and we charge them, they get disclosure through the criminal justice system, they become aware of our tactics, they go to prison, they sit around all day and discuss how did the police capture us this time. That they're aware of the new technologies as really everybody is, but particularly every young person is. And when they come out, start exploiting those technologies, and we're starting to see that, and that is our concern.
What sorts of technologies are they starting to exploit?
I don't want to go into too many specifics because I'm sort of aware that they're probably listening to me now, but certainly it is essentially particularly some of the new platforms that are available, some of the gaming platforms, some of the games.
That's what I was going to ask you about, the gaming consoles and platforms. And it's right, it might not be apparent immediately to everyone, but people can communicate with each other from these... I won't mention any trade names, but from these very common games.
As you're playing the games, and sometimes you're playing those games on the internet with other people, you can use that to actually communicate.
And then, so have you seen examples where some of these sophisticated criminal gangs are using those sorts of modes of communication?
We have, yes.
And would you therefore say that the legislation envisaged by this draft bill is a vital operational requirement for you in moving forward to defeat these criminal enterprises?
Yes, absolutely, I would. It is a vital operational need. We are very concerned about the new capabilities which are developing. We are very, very concerned that we will lose some of the ability, some of the capability that we have at the moment.
So, Chief Constable, has the law kept up so far with the criminal activities?
I suppose just about at the moment it's just about there, but clearly we see it fairly soon losing that.
Yep.
And of course there are issues absolutely about our own training, about making sure that we are exploring how new opportunities are covered by that legislation, that we talk to the commissioners about that and how that will do, and about how we create that capability within law enforcement. These are all challenges that we are facing, but absolutely we need the legislation to enable us to do that.
Because the status quo is fine, but further...
Mr. Stevenson wanted to comment on this before you move on.
But just to finish on that, Sir Peter, the status quo we're at the moment, but you would envisage, even by the time Parliament takes to pass legislation, we need to keep up with it.
We are seeing this immediately. I was only in one of my major investigation rooms this morning. We are seeing this now, so we are seriously concerned that in a short period of time we'll start to lose that capability, because, as I say, The criminals are very aware of this. They are aware of our tactics and the capabilities.
Mr. Stevenson, you have something to add then, Mr. Davis? Yeah.
Sorry, Chairman. I just wanted to give you an example of how that has been put into practice.
Yes, please.
Where we had an organised crime gang that was using mobile telephony. They were using that to contact a logistics company where they had details of certain consignments. They had those transferred to a different address and made off with the goods, and this was national. And they did this on several occasions over a 6-month period, where we were able to identify the mobiles used, worked that the whole way through, and eventually it led to very, very little. Other than we identified the methodology, that company shut it down so they couldn't do it anymore. They then transferred onto the internet, where they set up bogus accounts on the internet. They set up accounts that were very, very close to legitimate businesses. And from those accounts, they were able to generate email addresses that looked exactly the same, bar a hyphen that came from these. So they then got these companies, unfortunately, to transfer these goods again somewhere else where they made off from those. Now, we were able to get the IP addresses from the domain name where this was set up. It was set up using, they're very, very, very clever, using stolen credit cards, using Wi-Fi, using different bits and pieces that we weren't able to trace, until eventually we were able to find out that the IP address that logged on to create that domain account initially led back to the leader of the OCG's gang's house. So all we need is to keep the capabilities that we currently have. And I'm sure you've been listening to the news today where LTE has landed. That's long-term evolution, which is 4G. Now, 4G offers data over the internet in very, very fast speeds. It's much, much cheaper than ordinary telephony. So what we have at the minute is that we have, if communication service providers are keeping this data for business purposes, we can get access to that. If they no longer have a business need to keep this data, if they offer an all-you-can-eat tariff for everything, they won't need to keep any of this data, and this legislation is to try and protect what we currently have.
Mr. Davis, sorry, I'm just trying to make sure that Alan's in.
Thank you. And I agree with what's been said.
Okay.
I just picked up that people might have the impression that everything's fine about the current arrangements. This is not to diminish the importance of future-proofing, and the arrival of 4G is a great example. But everything's not fine about what we currently have. If you are using high-volume data inquiries to investigate an organised crime group in relatively slow time, a 75% hit rate may be adequate. If actually one piece of communications data is the difference between life or death, or serious harm to a child or not, then leaving it to 3 out of 4 is not adequate. I'd like to mention 3 cases very briefly, but I think it's really important I have a chance to mention these if I may. These are cases from within the last 8 weeks in CEOP. First, the good news. A contact between a child and a helpline service online, where the child indicated that they had self-harmed and were intending to commit suicide. Following normal procedure, this was passed on to CEOP as the agency that tries to reconcile the IP address to an individual. We do so in a very short space of time. We pass it on to the local police force in a very short space of time. They respond in a very short space of time, and when they go into the address where we have located this person, the child has already hanged themselves but is still breathing. Now, if there had been any delay in that process, or if the child had been unlucky enough to be using one of these service providers that doesn't come up to the 3 out of 4 mark, they would now be dead. I don't think there's any level of tolerance of the or acceptance that might have had a different outcome. 2 other examples where we don't know what happened. People we investigate, somebody using, I don't normally use these words, but I think it's important to convey this. Somebody using a paedophilic chat room called Child Rape, Torture, Brutality. That is the name of the chat room. An individual who's been on there once recently and once previously. Quite simply, we're unable to identify this individual because the communications service provider doesn't record the IP subscriber information. I'm sure you would expect me or any one of the 100,000+ police officers if we knew who was going onto this site, to do something to investigate them and mitigate the risks they probably present to the public. But this is one of these occasions when we can't, and I don't know who that person is, which is why I'm not afraid to share that with you. One more example from this month. Somebody offering online for distribution a number of indecent images of children, including files indicating the rape of a female 4-year-old. Unable to identify the suspect because the comms service provider does not record the IP subscriber information, no other lines of inquiry. Ladies and gents, I think it's really important to acknowledge that the communications data retention, accessibility and availability is the difference in some of our cases between children coming to serious harm and not. And I'm grateful to have had the opportunity to convey those recent cases to you.
All of those cases, it's IP addresses were the missing ingredient.
Yes, we were lucky.
Not everything else in clause 1.
Yes.
Mr. Davis, if I may say so through you, Lord Chairman, you in child exploitation and your officers do a very difficult job and one that's very much appreciated. And thank you for enlightening us about those examples. I take it from that you would wish to emphasise that it's not just a question of the status quo, retaining abilities that law enforcement currently have. We need to move in line with advances in criminal activities and therefore enact measures that will help law enforcement deal with these issues.
Absolutely, and my point is that the status quo, while tolerable in most circumstances, I don't feel is tolerable in the circumstances I've described.
Thank you.
Thank you very much. Mr. Hubbard, and then Lord Strasbourg.
Thank you. So Peter, you were talking and following, I have to say very nicely, the Home Secretary's line about games and other online activities like that, and how legislation was needed because people talk on games. Can you tell me which bit of RIPA doesn't apply to that already?
Well, I think it's not about, RIPA. It's about that exactly as Mr. Davis described, about the fact that the organisations that are providing this capability have retained the data, so that we can actually, identify who the people are actually using.
So you're saying that actually the whole issue about whether it's online games and the fact that people do all sorts of things like that is actually a complete red herring. It's actually about whether you have the IP address data.
Yes, absolutely. Fine. It's about whether that provider has retained that data and we can get into it.
So you'd advise the Home Secretary to talk about IP data rather than online gaming as a particular issue?
Well, I think, we are just trying to give, and I probably think she drew it from me rather than me draw it from her, but clearly we've been talking to the Home Office about what we are seeing in terms of the methods that criminals are using. So, we've used that as an example, but, I wouldn't want it to limit to that. What we are seeing, as I say, is a huge development of apps, of different offerings from different providers, and some of it which can only feel certainly that it's only designed as a means of getting around law enforcement. It's hard to understand, and some of it is also to get around of not being charged. So we know that there are services where essentially you can get a phone number and a means of communication, which essentially means that you're no longer paying a mobile phone bill. So it's that sort of thing which we are concerned about, which is developing.
Mr. Whittaker.
Can I just ask for absolute clarity then? So one would presume that because you know about these apps, you know about the gaming scenario, that if you need that information, you can approach these companies and get the information going forward. The issue, I presume, is about what's happened. Is that right?
The issue is clearly whether that company chooses to retain that data.
But you can still request them going forward to retain that data for a period of time, so that they could help with your inquiry. And I know it's not going to help in a life and death situation, but for serious crime, which is what you're talking about, it's about actually what's happened rather than what's going on at present.
Yes, that's right. But I'd agree with what Mr. Davis says. I mean, clearly, even in terms of our current capabilities, there are a lot of frustrations. Because again, if you're talking about mobile telephony, the criminals will do everything they can to make it more difficult to identify who's got what phone. But that is, a separate issue really.
Lord Strasbourg.
Mr. Stevenson, can we go back to the example that you gave us, which was a very interesting one? Presumably that was an ongoing investigation where you had identified suspects. That you surely intercept evidence would have given you everything you needed and far more than you would get out of communications data.
My knowledge of that is very, very limited. It's a completely different area, and I wouldn't be able to speak about it.
That isn't, well, my understanding is that this is exactly the sort of case where you would go to Intercept with a warrant, and you'd get all the information you want and more that way.
Again, I'm unable to speak about that specifically. However, if the Lord Chairman wants, certain evidence can be given in a written form.
Okay.
Yeah, I think, yes, we will ask briefly on that, because it did strike me as well that probably going to the Secretary of State's warrant in Northern Ireland to get intercept evidence when you've got known suspects may have been a route. It may have been used and you're not aware of it in any case at your rank date, Mr. Stevenson.
I think we would have to say that the criteria for getting intercept from Home Secretary's signature is extremely, extremely high. And therefore, we would not normally think about it in a case which involved a sort of theft of property in this way.
Mr. Higgins?
Just a brief point. The focus has been very much on serious and organised, and I completely understand that and support everything that's been said. I think there's another facet to this that may be worthy of note, which is the unwitting. So a lot of these technologies are now used as a matter of fashion rather than a deliberate attempt at subterfuge, and I think that's a key point to bear in mind. Policing is clearly, our primary focus is about saving life, followed up by prevention and detection of crime. But the issue is that certainly for the general public, a lot of their key concerns are actually about volume crime. And in these areas, I think where you've got unwitting use of technology that does frustrate, then that is a problem. And to come back to the point that you made about the other alternatives that are open to us, clearly in those cases that wouldn't be an option.
Okay, DCI, Higgins. A lot of these things you say may be fashion, and there's a problem for the police in keeping up with it. We've had evidence from witnesses in the past who've said that a large part of this problem could be solved by better police training or better Spock training, so they can actually know what they're asking for from the huge amount of extra information you now have available. Much more than you had in the year 2000. But perhaps are the police fully trained to ask the right questions and to spot the evidence that may exist at the moment?
So I think there's probably a number of questions sitting under that one, Lord Chairman. So if I can perhaps try and address them in order. Are the police equipped? Do they have sufficient knowledge? We conducted in April 2010 a national training needs analysis to look at just this very issue. And we identified a number of skills gaps, not just across not just in relation to accredited SPOCs, but also in relation to investigators and analysts in particular. We've approached that over the last 2 years in a number of ways, specifically in relation to SPOCs. We introduced a programme to refresh the knowledge of every accredited SPOC in the country, and that was in the form of a 3-day course that was rolled out. We are currently looking at the accreditation of SPOCs and reviewing that, and looking to introduce a programme of continued professional development, applying a framework of information. So moving away from perhaps the old approach of a single course and then a number of ad hoc attendances at seminars, through to a more consistent national standard in that regard. Move on to investigators and analysts. Again, there was a significant gap that was identified in relation to this. And the way that we've approached that is we introduced a 5-day course, which is the Core Skills and Communications Data course. That's now been rolled out since October 2010 to over 5,000 police officers and staff. The follow-on from that now is that I'm now looking to embed that training within existing programs of training that are rolled out to training detectives, so within the Professionalised Investigation Programme, which is a national programme run by the MPIA, so that the standard that we sought to bring up detectives to 2 years ago, a year ago, is now embedded within new-to-role training. And we're looking now specifically at more specialised areas of training, So in relation to analysts, we've just rolled out a 6-day classroom-based course for specifically targeting analysts in the use and exploitation of communications data. We've also rolled out a specialist course for radio frequency technicians, and we're currently looking at the possibility of rolling out dedicated training for a more limited number of detectives who are specifically involved in the more high-profile, complex and serious investigation of crime.
Okay, what training do you do on advising SPOCs and officers on what is necessary and proportionate?
Clearly that's a key part of their role. So part of their responsibility is to act as guardian and gatekeeper as outlined in the codes of practice. They're there to provide independent advice and judgment, if you like, both for the applicant and for the designated person who authorises the application process. They are taught very much to understand the difference between proportionality and necessity, and that is a key part of the role, is to scrutinise the applications that they receive. So if I look at proportionality, it's about does the level of intrusion into someone's privacy, is that balanced against the benefit of the data that will be achieved, or rather the benefit to the investigation of that data. And necessity is about linking up the links between a mobile device, a crime scene, and potentially witness suspect.
Now, we're aware of the filter arrangements, the RHID scheme being developed. If for the filter to work, there's a standardised Home Office run set of questions or programme or format, do you then see less role for training SPOCs if it's all going through a big centralised Home Office filter system?
No, I'm afraid I don't, Lord Chair. I think there's a basic requirement, and this has been reiterated by SPOCs such as Dave, that have been through the course and very experienced now. There's a basic requirement there for all SPOCs to understand legislation, the application of that legislation within an investigative process, the network operation, so how networks actually operate and function, and also the data that's available to them. So that's a basic requirement. I think the arrangements that you refer to that are set out within the bill will help in certain circumstances, but potentially to reduce the burden on SPOCs. And again, this has been identified as a key challenge, that as more and more data becomes available, and the thirst for data and information, not only to convict, but actually to the investigation is about proving guilt and innocence, clearly. So it's about corroborating alibis as much as it is attempting to prosecute. I think the importance there is that potentially that will reduce the burden on the SPOC and the SPOC unit, but that will in turn enable them free up their time so that they can provide the advice and support that they're there to give to investigative teams.
Would you be happy? Sorry, yes, Lord Strasburg.
Do you have any training material on necessity and proportionality that you'd be happy to share with the committee?
I'd be more than happy to share any training material, or indeed, if the committee were minded, I'm quite happy to facilitate a brief demonstration of maybe a mixture of the training.
I think missed the slot on that one, but the material would be useful.
Okay. Dr. Hubbard.
Thank you, Lord Chair. The training is clearly very important, and the testing and proportionality is really hard, and it assumes that there is a reasonable way of judging that. You'll know, presumably, that Derbyshire Chief Constable Mick Creedon said, who runs Derbyshire Police and speaks on serious organised crime for ACPO, he said about proportionality, if I'm driving on the motorway and I see someone on a phone and texting at 80 miles an hour, that for me would pass the test of proportionality immediately. Would you agree in the absence of any other information with the Chief Constable?
I think it would be inappropriate to comment without the absence of any other information. I think it's key to recognise that each case is considered on its merits.
But he said, given just that information, that would pass the test. Now, I realise he is a slightly higher ranking, but would you be training your Spocs to reject an application from a Chief Constable? And if not, are you not concerned that another Chief Constable may come in with something like that?
Absolutely, we do train our Spocs to be very, to accept the position that they may well have to challenge upwards, and that's part of their job, and I think that's accepted.
And so you train your Spocs that if they got a request like that, they would say it was or wasn't proportional?
As I say, I'm not going to be drawn on a specific case without further information.
I would be expecting them to ask, well, again, what is the context? Is there a problem with fatalities on that particular stretch of motorway? Were there other, circumstances?
And if there weren't?
Sorry?
And if there weren't any other circumstances?
I think what we're showing is this is a
we're getting a wee bit.
I personally would probably.
We're getting a wee bit hypothetical now, and into Chief Inspectors challenging Chief Constable. But Mr. Davis wanted to comment here.
Which, if I may say so, in the context of RIPA, they're welcome to do, and those are part of the rules. And I know you know what I'm going to say. I don't recall Mr. Creedon actually saying that. I know it was attributed to him following a press conference, which I also spoke at, and I don't remember him saying that at the time. Following the last committee appearance, I checked with him whether he'd actually said that, because I must admit I would have been mildly surprised if he had. He said my recollection of what he said was accurate, which was that if you're investigating a fatal road traffic collision on a motorway, it's of evidential relevance whether somebody may have distracted themselves at the time of being involved in the collision by, for example, making a telephone call or texting. I think that would be proportionate. I think that's what I heard him say at the time, and that's what he recalls having said subsequently.
Certainly, I have a completely different recollection, because I sat there at the time as well. So, but we will not debate that today, and we will not be probably using it in our report. Yes, sorry, Mr. Allen, did you... I should say Mr. Allen. Detective Superintendent, sorry.
Thank you. I think it may be important at this juncture just to highlight the issue. Not only is it important to sufficiently train our Spocs, but also it would be helpful, I think, for the committee to understand just where they are located and their relationship to their colleagues, because they are very much separated from the investigative team, and they work in a very confidential environment, that they are vetted to an enhanced level, and access and control to those members of staff working in that suite is very strictly controlled. Okay. So they do take their role as gatekeepers and challengers of senior officers where it's appropriate very, very seriously, and I, as the senior responsible officer, do support them in that. It is a very, very important and key role for which they're properly trained, as my colleague has just outlined, but that's also a continuous professional development programme of regular training, attendance, and of course we are still under the scrutiny of IOC.
That's okay. I think the committee's seen sufficient evidence that we're reasonably assured that they're not just rubber stamping the requests of their pals. We realise that. My final question for me on this. Would you put the Spock system on a statutory footing on the face of the bill, the same as the authorised officer? Any thought, Mr. Lyon, before I'm going to...
I'm not quite sure whether there's a need, and there's we talked about necessity and proportionality. I'm not convinced there's a need at this stage to do that, and to be specific, as in the authorising officer's role. For me, I think my experience of the Spocs, the way that they fulfil their duties, the way that they protect a very sensitive tactic and do it in a very responsible manner, doesn't give me cause within Greater Manchester for the need to do that.
Though there may not be a need, do you think it would give public reassurance?
I think there are perhaps other ways of giving public reassurance. I think the inspection process that is independent and separate from the police may be an opportunity to develop some sort of public communication programme that can reassure us that, reassure the public that Greater Manchester Police treats this particular sensitive tactic with the utmost respect, and we deal with it in a very lawful and transparent way.
Okay, so could that inspection process be beefed up a little bit?
Again, the inspection process is at the discretion of the independent panel, the Intercept Commissioner, and if there was any concern about our handling of such a tactic, they would inspect us more rigorously and more frequently than they do. So I do find that the IOCA process is robust. Incidentally, our inspection takes place on Monday, and the inspectors will be with us for 3 days. and they will explore a broad spectrum of our work, from serious and organised down to divisional crime, level 2 criminality, that we investigate and apply the tactic to. So it is a very robust, and they'll be speaking not only to the SPOCs, but also to investigators and applicants and every tier of the process.
I personally think it would be a benefit if the public perhaps understood a bit more about how seriously we do take this issue. I mean, I've certainly seen it in counter-terrorist cases where almost, the view is, for instance, the police can go around sort of tapping everybody's phone, which is clearly not the case. So I think sometimes the frustration, we put a huge amount of care into this, there is a huge amount of recording of data, and yes, I think sometimes it's frustrating.
There's a lot of misinformation.
Absolutely. That, I think it's frustrating that the public and some of the commentators don't seem to understand. And we guard this very, very, and I guard it very, very seriously, because this is an important capability. If there is any concern whatsoever from the public that we're using this inappropriately, that will be a huge damage to policing and a huge damage to victims of crime. So, my people know that I treat this very, very seriously, because it is a very, very valuable tactic. And if there was any cause for public concern that this was being abused, then, as I say, it'd be very damaging to the police service, probably more important, very damaging to the investigation of crime and detection of victims.
Mr. Davis?
Notwithstanding what Sir Peter and Mr. Lyons have said, the only other thing I'd comment is, having tracked this debate for quite some time, if we had the choice between a beefing up through legislation of the existing process of authorisation, transparency and accountability, I would regard that as preferable to the replacement of it with something entirely different, which was one of the ideas in more circulation at the time of the last committee and prior to that.
Okay, beefing up. Okay, you used my phrase, beefing up. Okay, what's the beef?
Well, I was using the term beefing up in, I think, the same way as you were trying to use it, which is actually enhancing a system that's already there to provide a greater level of transparency and accountability if that's required.
Okay, I think, Lord Strasburger, can we jump to your question 15, because we're on this subject. I will come back to Lord Armstrong and the other colleagues. I haven't missed them out. But since we're on the Information Communications Commissioner.
Yeah. We've received evidence that the Interception and Communications Commissioner, or a new body, should have a more public role in reassuring the public that communications data is being used responsibly. How often are external checks presently carried out, and what does the checking consist of?
I would certainly, from my point of view, as I've sort of indicated, would actually welcome, absolutely, more public reassurance. Clearly what we wouldn't want is that to get into the description of some of the tactics which are being used. But I think it will possibly be something we want to discuss with, obviously, the Police and Crime Commissioners when they are elected later next month. So absolutely, as I say, I've got some frustrations that I would like the degree of seriousness that we treat this area in to possibly be better, reflected with the public. I mean, I think you've heard we have a very rigorous inspection regime. We treat that very seriously, and to some extent, of course, that is monitored week by week, because again, certain of the authorities, RIPA authorities, have to go to the commissioners, and of course, if they don't approve of them or think the ones that we've approved were inappropriate, they will tell us very rapidly. So, there is already the inspection regime, but as I say, there is the almost daily monitoring of authorities and RIPA authorities, and feedback coming back as to, well, we agreed with that one or we didn't agree with that one.
The Interception of Communications Commissioner's report for 2011 showed that they had carried out 22 fewer inspections of police forces in that year than there were police forces. So I can deduce from that 22 police forces didn't get inspected that year, and presumably then went 2 years without an inspection. How frequently is your force inspected?
Once every.
My Lord Chairman, it's at the discretion of the commissioners. We were last inspected in September 2010, and again at their discretion, they're now due to visit us in November 2012. And for me, when we debrief the report on their findings, and indeed brief the Chief, we look at the recommendations, we look at the advice, and in fact in their last inspection process we have streamlined some application processes because they found us being too challenging to our applicants, and we've taken that advice on board and worked together number of applications and streamline them where they're appropriate, and that's fully within the legislation and fully within their guidelines. I think the very fact that they're coming back from 2010 to 2012 indicates a degree of confidence and satisfaction in their findings during that inspection.
But I think, Sir Peter, I think you were saying that you'd be comfortable if the inspections were at least annually, to give the public more reassurance. That's what I understood you to say.
It's really about, I think, though, the way that that's communicated. I mean, essentially, you know, if there was an inspection every year, but really the public were unaware, then it wouldn't really be serving a great deal. I think there is an issue about how do we communicate to the public the seriousness with which we treat this area. And as I say, at the moment, when there are particular community concerns, perhaps, about a particular investigation, and often it is in the counter-terrorist world, you know, I think we certainly at that stage feel that some of the public and even some people who appear to be well informed don't actually understand how seriously we take it. But I would come back to it. You know, there is almost a daily interaction, and we've had a particular type of authority where essentially the commissioners did not agree with us, and we had a fairly open conversation about it. But at the end of the day, that was their decision, and that was their decision. So you know, it is a constant relationship in terms of how seriously they take it.
And are there any other changes any of you would like to see to the existing system?
Just perhaps something to add, looking at inspection regimes, but maybe something worth pointing out is that the process by which we acquire communications data is subject to routine scrutiny, because it is always subject to the CPIA, so there is a requirement upon us to disclose that process through the courts. I requested just a brief review through the Metropolitan Police prosecution support team and asked them whether they were aware of any adverse court decisions on the basis of an abuse or a breach of that process, and they weren't aware of any.
Lord Fawkes?
Sir Peter, we have an independent reviewer of terrorism. To understand what you're saying is that you would really like the equivalent publicity and priority and prominence to be given to those who are monitoring, Information Commissioner, monitoring what you do, so the public gets an idea that there is someone independent on the case and reassuring them.
I would be very, very clear that policing has always benefited from greater transparency and accountability. And I'd be very, very clear about that, as long as there's nothing which actually, you know, perhaps by slowing things down makes things more difficult. I mean, I think it's always interesting as well. You know, we inspect on the basis of almost, have we abused this legislation? We're never really inspected on, are you making best use of this legislation? And to be fair, I have had some commissioners who've said to me, we think you could actually do more of this. We actually don't think we're getting enough applications from your force. It was from a different force that I was in. So I think, you know, I think we've made it clear that we're trying to keep up with the training requirement, but I think as every organisation, when you see the way this capability is growing, we absolutely do have a challenge in terms of training our staff, making sure we recruit the right staff to absolutely understand the capability, understand absolutely their legislation, if we're going to keep up to that, and therefore absolutely independent people who can help us and challenge to that. And for instance, we in Greta Magister are talking to our universities about whether they can help us in this sort of area around research and capability and those sorts of things. So, but you know, the general point I would make, as I say, is that policing has never had anything to fear from greater accountability and transparency. If that reassures the public that we're using this properly and then enables us to use the capability to then protect victims of crime, that is really essentially got to be a win-win for everybody.
Are you aware, Peter, of any forces who may be employed next to the Spocks, people who may be called computer geeks, who may not have been recruited initially for their police constable abilities, but because of their knowledge of what to look for, what to ask for on all the...
Yes, I mean, I think we are increasingly trying to do that. And I mean, you know, part of my reflection almost is that I need to recruit a room full of 14-year-olds. You know, to do this sort of thing. But, you know, there is a serious point to this, that certainly some of our forms of recruitment in the past are not going to help us to survive in this territory. And therefore, no, that's one of the reasons why we are talking to universities about whether they have good people that they would like to lend us in terms of some of their research, internships, those sorts of things. So absolutely, we understand better the capabilities.
Baroness Cohen?
Well, we formed, I think some of us who visited the Metropolitan Police formed a very favourable impression of the whole Spock process. And think what we're trying to address is there a better way of not of doing it, but of getting it known that this bill could be deployed to use. That is why I think we're asking whether the system could be made legally enforceable. Because that would be infinitely reassuring to quite a lot of the general public.
I think, certainly as, Chief Constable and sort of from ACPO, I mean, clearly we now have a lot of defined roles in policing in terms of, all sorts of high-risk areas like firearms, counter-terrorism, even the investigation of murders that, for instance, you've got to be a senior investigating officer to investigate a murder, you've got to have a record of achievement, all those sorts of things. Now, we don't specify that in legislation, but it is absolutely there as what we now call approved professional practice, which will now be signed off by the new College of Policing. So I think we recognise that there is a need to show the public that we are professionalising policing and that absolutely there are key roles that we treat very seriously and are common across all forces. And really overall, that is the way that we'd like to approach that, probably rather than just picking out particular roles. Because I think, as I say, the public should be equally concerned that the people who, for instance, are in charge of firearms operations themselves are trained to a certain level and it is treated very seriously. But I think it would be a difficulty if we started to define all those different roles in legislation. It's rather about saying we take all these things very seriously in high-risk activity. It's now in the new strategic policing requirement, which again has been approved by Parliament. And as I say, we'll then go into an accreditation scheme in the new College of Policing.
But on the other hand, we don't have sort of deep public concern and thousands of people worried about how you investigate murder. And we don't have specific legislation on that.
No.
We're facing specific legislation here on a technical area, and there's deep public concern at the moment.
Yes, indeed.
And therefore...
Indeed. And I think, as I've said, anything which would perhaps reassure the public and which would increase that transparency and accountability, then we would not have an argument.
Okay, we'll move to Spox, if we may, and Lord Armstrong. Moves back to Spox.
Thank you, Lord Chairman. I wonder if you would see any merit in creating a team of highly experienced and trained, what you might call super Spox, who could provide oversight and advice. I'm not suggesting that the Met or Greater Manchester necessarily need it, but it might be useful for across forces, with the police forces, and particularly those with only have occasional access to this.
Yeah. I mean, I think we would recognise that in organisations like the NPIA and the Metropolitan Police, and even in CEOP, there is already a sort of foundation of expertise. And again, the idea is that as we develop, particularly the College of Policing, that we absolutely would like to have the idea around Spox and that expertise about this area absolutely within there. Now, to a degree, we have that at the moment. You saw that in the case in Wales, that when we've got a particularly complex search, then you can go to various experts around the country who will help you as a police force how to carry out that search. And so I think your suggestion is a good one, that essentially in this sort of area, there should be absolutely identified a group of experts that if a particular force wanted to go to. And I think I've also expressed, the concern I have that we need to build this capability for law enforcement. And we will be talking to the Home Office about, well, in the new world of the National Crime Agency and the College of Policing and other developments, where will we as a country be developing that capability around our understanding of communications data and the way that crime is going on to the internet in general. And I would identify that as a country we need to build that capability. But particularly, as I say, around that area of expertise, around Spox in this particular area, absolutely I would like to see that developed within the new College of Policing as a community of good practice, where again an individual force could approach if they wanted advice about a particular issue.
So, encouraged by that answer, Sir Peter, I wonder if I could ask a more general question, which you may not want to answer, I don't know. But there's a scheme whereby local authorities who are minded to use communications data for investigations can use the services of the National Anti-Fraud Network. They don't have to, but they can use their experienced Spox in the National Anti-Fraud Network. And the evidence we have received suggests that the experienced Spox of that network do a very good job. I wonder if you think that it might be sensible to widen that service so that all the public authorities which use communications data only occasionally had to put their requests through a centralised Spock service, so that we got the level of experience and training and common practices and common standards in relation to necessity.
But I think in general we would support that. I think our concern has been that obviously sometimes the reported use of this type of legislation by certain other authorities has created the danger of calling it into disrepute. And I think that is, a risk for us in law enforcement in general, if the public and the media feel that some of that legislation, which they believed was intended for more serious forms of crime, is used for activities which the public themselves would not see as serious. So, that greater, I think, national oversight of that, I think we would welcome.
Well, on the subject,
does Mr. Davis want to add to that at all?
I just want to endorse that. I think most police forces use this kind of authority process fairly frequently, and practice may not make perfect, but it makes far closer to perfect. If it's used rarely, then there won't be the expertise, and provided that expertise is provided from somewhere through a scheme such as the one you described, that's got to be better than leaving it to people getting to grips with these kind of powers. So I endorse what Sir Peter says. Thank you.
On bringing things into disrepute, you and many other witnesses have said in the Home Office and public session last week, what we really need are IP addresses and weblogs. You and others have said we're really interested in who, what, where, who, what, when, and possibly from where.
Not what.
Not what. So no, that is correct. Who called who, when, and possibly from what location. Pretty narrow. We've had a witness who said, if that is all the government wants, it is totally unfair to designate this bill as a snooper's charter. But if Clause 1 stands, as it does at the moment, then it is fair to designate it as a snooper's charter. How concerned are you that we've possibly got a draft bill which has been brought into disrepute because the Home Office have phrased Clause 1 so widely that theoretically everything could be caught, there's been inadequate consultation on it, and yet as we get further and further into our inquiry, it seems that what they want and what you want are much narrower things than Clause 1 designates. So my question is, have we Home Office made a rod for their own back in making Clause 1 so wide? Because it doesn't seem to be what you need.
I think we were obviously, I think, very, very concerned about some of the initial publicity and some of the public debate about this proposed bill and some of the earlier forms of this bill, because I think we felt it was very, very ill-informed, some of that debate, and didn't take into account the nature of crime as we see it and the nature of organised crime and the reality of the tactics that the criminals are using. So I think, unfortunately, it was that debate, and of course, again, Chief Constables on the whole were wary about getting into that debate because it was becoming party political, and we are very wary to get into that space, particularly after certain experiences we've had in the past. So I think, unfortunately, that created a lot of misinformation that this is now playing into, and it feels like a bit of a catch-up to try and get across how serious this is. I think in terms of the way the bill is formed, I think we've certainly tried to express that it's trying to get the balance about absolutely reassuring the public and get the balance of civil liberties right, but on the other hand trying to make it that it is broad enough to capture what might be future developments so that we don't have to keep on coming back to this area.
Okay, Mr. Davis, what do you think?
Yeah, I think I will skirt around some of the observations you might be inviting me to make about how the bill was formed and so on. I think where I find my limits is in expressing the operational requirement for this kind of data to be captured, accessible and available in quick time when necessary to a whole variety of agencies whose business is to enforce the law and protect the public. Whether Clause 1 overextends what's actually necessary, and it may well, that's got to be a judgment for legislators in my view. I think that there may be some aspects of what's included that are more essential than others, but here's the thing, we're not legislators, we're here to express an operational requirement for for data. So I'm not sure I can answer the fullness of that question, but we understand entirely the need for accountability. We understand the relationship between possibly future-proofing this legislation and creating too much freedom and flexibility. I don't regard myself as an expert on how to navigate that, frankly. What I can say most clearly is that we look to you and the legislators to navigate that on behalf of the public, so the right balance between the need to protect the public from harm and protect the public's rights to privacy is struck. I'm not the person who would advise you how to do that.
The only other observation I've made from my experience is overall what has benefited this country and law enforcement is that we have been given the capability to use certain powers and certain capabilities which are sometimes denied in other countries. But then what has controlled that has been the level of oversight and inspection and regulation around that and the attitude that the courts take towards that. And I personally think that is the right balance. You go to other countries where, for instance, there's no CCTV, the public would not trust the police with CCTV, whereas I think in this country we've got that facility, it is there available for the public, but we treat it very seriously and control it very seriously. And for me, that is the right balance. That's why we would say we would absolutely welcome any form of oversight or inspection if that reassures the public. And that reassures them that the police are being properly overseen and regulated. And then, as I've said, the victims of crime and those that may be victims of crime are getting the protection. I think the worst of all worlds is when society doesn't trust the police, doesn't give them the powers and capabilities, and actually it's the victims of crime then lose out. And you do see that.
Mr. Ellis has got a question.
Thank you, Lord Chairman. Just further to the point you made, and I'm not going to invite you to make politically loaded remarks, far from it, but would you say that the media coverage has, in places, certainly in the early stages of this matter, been a travesty of the truth? I mean, there's certainly talk of the Home Secretary being able to read people's shopping lists and the content of email. A lot of that was grossly misinformed. I mean, that's not a political point. That's simply an accurate reflection of what the draft bill says and what was being reported. Is that, would you agree?
Yeah, no, I would agree with that. And obviously I do see it from a certain point of view as somebody who sees the consequences of serious and organised crime in communities and the way that it blights the lives of people and destroys the aspirations of young people. I have that particular view of it, and in some of the comments I just did not recognise that people saw the reality of what it is that we are dealing with and the threat that it poses. But I would also say that another break we have is that, this is the resources one. I do not have the resources to go on fishing expeditions to read people's shopping lists. Every day we have to look very, very carefully at a huge number of threats and where can I concentrate my resources. And some of this capability we've talked about is very expensive. I was looking at one investigation this morning that's cost us £30,000 just in communications data. And therefore, there are breaks in the system as well. But, the situation we are in is that we have to look at the highest threats. We're often looking at people who've already got pretty long criminal records and trying to deploy the tactic against them. So we just do not have the capability or resources to go into these phishing attacks that people have described.
Lord Armstrong.
I just wanted to come back to this question of what they call future-proofing. We've got a bill in Clause 1 which endeavours to future-proof by throwing its net very, very wide. That has alarmed people, as we've heard. It's an attempt, insofar as it's an attempt to future-proof, it's a very difficult thing to do in any other way because we don't know what the future is going to be. So the only way you can proof against the future is by these very general provisions. The alternative is something more limited now to deal with today's problems and some kind of legislation in the future as new problems emerge. You will probably know as well as we do that there are great pressures on the legislative timetable. It's not easy to get legislation on such a subject frequently or quickly. And I wonder if you have any comments on that dilemma, because I think it's one of the dilemmas we face.
Yeah. No, and I would totally agree with you. It would seem to us that, again, when you look at things like the potential development of 4G and other capabilities, that it's really possible for legislation to keep up with that. And therefore, I would say that the alternative of the way you then operate the oversight regimes, the inspection regimes, the regulations which the Home Secretary may make to control this form of activity, the way that the courts then view that, that is, a much better safeguard than trying to go through the legislative timetable to catch up. And that's, for me, is the right way to actually try and get the balance. But as Mr. Davis said, we're not experts on this, but I think the concern, absolutely, in lots of areas we see, is just the way that technology and societal attitudes are changing, which is very, very rapidly, for legislation and some of our processes to keep up with that is becoming more and more of a challenge.
Lord Jones, you're content here?
Briefly.
Okay, I carry on then.
Then I shall be content. Lord Chairman made his remarks about Clause 1 just now. Really a summation of a predicament we face with the draft bill. Should we presume that in the private councils of ACPO there have been debates, lengthy debates, concerned debates? Does ACPO really get its teeth into the issues before it presents itself publicly?
Absolutely. We've had a lot of discussion about this particular issue, and as I say, some really serious concern and worry about, essentially what we're going to do in the future if we lose some of the capabilities that we have at the moment, because we have become so reliant on them. Because things like interrogation, which perhaps worked 30 years ago, we're no longer in that same. Use those same tactics, shall we say? So, it is just,
let's be clear, you're not calling them to be brought
indeed,
back.
I've been around too long. It is about having to get absolutely hard evidence from technology. But obviously there is a lot of angst at the moment about the level of public confidence, about questions of police integrity. And we treat that very, very seriously. So, and obviously there's been a lot of debate as well that when issues become party political, and there is an operational policing issue in there, how do chief constables intervene and get the point across? And we do treat that very seriously, because I think most of us think it is incredibly important that policing stays out of party politics.
I assure you I shall waterboard Lord Jones later on. Mr. Davis.
Thank you. I'd just like to offer up a thought about Lord Armstrong's question, which is I think the basic principles of what communications data should deliver, I don't think they change. They are about subscriber information, service use information and traffic data. What changes is where you might look for those pieces of data in a changing technological world where people are far more adept to it. People use social networking, for example, or gaming technology as their chosen means of communication. Those are the things that change. The principle of what we're looking for is actually exactly the same. Although some police habits have changed, as we've noticed over the last 30 years, looking for that kind of data, whether it was on a landline telephone or in the technology in 5 years' time, is what this is about. And if it is possible to frame some legislation that enables law enforcement to carry on doing that, whatever the technological means by which that data may be found, that is, I think, what would be the best interest of protecting the public.
Okay, so we can put the principles into a bill which we amend every 10 years like REPA, but then if we were to be able to recommend to the Home Office, and if the Home Office were to be able to find machinery whereby the technical bits of where it can be found could be amended by order every year by the Minister or and through parliamentary scrutiny, you would be happier then that Clause 1 was not so wide-ranging?
I'd be happy enough. The operational requirements I keep repeating myself. I'm not a legislator, I'm not an expert on framing legislation. I can tell you what the operational requirement is. It's as I've articulated. The best way of enabling people whose concern is the protection of the public to access that communications data when they need it in a proportionate, lawful, accountable, necessary way is what we're looking for. What you've just described doesn't sound like the worst of the options by any means.
Thank you very much. And finally, Dr. Hubbard.
Thank you, Lord Chairman. And Mr. Ellis and I don't always agree on everything to do with this issue, but there's one thing I just wanted to agree, which is that some of the media coverage in this area has not been very accurate. And there's a risk about overstating what it will do, but also understating it. There was an article in The Sun at the beginning of this which said only suspected terrorists, paedophiles or serious criminals will be investigated. And presumably you wouldn't want to see inaccurate statements like that made when it would be used far wider. Is that correct?
Yes, absolutely. Yes.
Yeah, I mean, that was the Home Secretary's article, so I hope we'll hear from her tomorrow how she would correct it.
There has obviously been some debate as well, recently about the growing workload we're getting from investigating harassment on things like Facebook. And some people seeing that as fairly low level. On the other hand, if a young person, God forbid, commits suicide because of bullying and harassment, the coroner may well have something fairly direct to say to the police force, as did you do everything to try and investigate that? I think that shows that these are serious issues, and therefore I think that's why it's been difficult for policing overall and legislators to frame what's serious crime, because often it's a bit like the guy texting on the motorway. It only becomes really serious when you see the consequence of did somebody die as a result. So, that's part of the complication in this area. But, I think, as Peter and Mr. Davis has shown, activities on the internet, that form of communication, the ability to commit crime on the internet, whether it's stealing goods and getting them delivered to bogus addresses or some of the other activity, is clearly an increasing part of our work.
Okay, thank you very much. We've had a long but very worthwhile session. We are very grateful to all of you for coming here today. Detective Chief Inspector Higgins, Sir Peter Fahey, Chief Constable, Mr. Davis, Detective...
I think Mr. Higgins is a superintendent. That's correct.
Did I say, what did I say?
We don't want to de-rank him.
I'm so sorry.
Not yet, anyway.
I'm so sorry. I thought you were Chief Inspector. Detective Superintendent. That's very, very... As someone who brought back the Chief Superintendent rank in 1996, against all Home Office advice, I'm pleased to give you that recognition. Also, Detective Superintendent Lyon.
Thank
you. And Detective Sergeant Stevenson. Thank you all very much. Your evidence has helped the committee, again, slowly claw its way towards a possible solution, or a possible report for the Home Office to come up with a solution. Thank you very much.